May I please, Your Lordship? My Lord, item number 39. This matter was listed on 20th of this month, Lordship, on last Thursday, for final disposal. But due to paucity of time, that matter could not be taken on that day. May I pray that this matter may be upgraded today? It was for final disposal on that day, Lordship.
Mr. Counsel, it is not possible. I have already so many matters today at 2. Impossible.
Then, my
Just
Lord,
in the list,
Lordship, I have.
the only court having 71 matters.
Yes, Lordship.
Is there any other court who
They-
has 71 matters? Tell me.
No, Lordship, then matter may be taken on any other day for final disposal.
We'll see when the matter reaches.
Offline, Lordship.
In item 58, I have filed an affidavit in reply that may kindly be called. Much obliged.
Yes, Your Lordship, with the consent of the other party, I beg to mention item 28. So the conducting counsel, he is on leave till Friday, any day next week, Lordship.
Interim orders.
Interim orders? Sir.
Interim orders, no.
No. no.
What is the matter about?
Lordship, I'm not in the case.
Read the file. And see.
It's about construction of drain, Lordship.
2020 matter, 6 years. What are these?
My lord, reduction of the amount of the forest royalty, my lord. The last occasion, forest department was directed to produce the instruction, my lord.
Lordship, in this matter, we're awaiting instruction, but the issue is that the PWD has deposited the amount directly to the treasury officer and to the head of account of forest department. That instruction the PW has given us, a Lordship. So now forests are taking up because there are lots of the series of matter, Lordship. So every detail has to be taken up from to find the proposal, Lordship. To submit a proposal, we'll take the details, Your Lordship, regarding this. Because the amount has directly been deposited to the treasury under the head of the forest.
These orders were passed sometime in the year 2018.
Yes, Your Lordship, but
Does it take 8 years for that?
the Lordship, the issue is here is that in this matters, we were recently involved in this matters, the Lordship.
Why?
Because you don't know, forest
Rate petition states, my lord, the forest department was not the party, my lord. The grievance was against the PWD department. Directions were issued to them, my lord, to release the bill. When we filed the contempt petitions, my lord, the instruction come from the forest PWD department that they have already deposited the money to the account of the forest department. So that's how the forest department has now come to the scene, my lord.
So, the PWD had deducted. And the forest PWD thereupon had deposited in the forest department.
Forest department,
The direction was to the PWD.
PWD, my lord.
The PWD had already deposited to the forest department.
Yes,
So
my lord.
therefore, your case is against the forest department.
Yes, my lord. Now, my lord, the forest
But can
department
we-
has to release the amount.
Can
my
we
lord.
exercise that jurisdiction in a contempt?
My lord, as per my lord, the PWD's directions.
Now with the PWD categorically stating, we may close this direct, taking into account his statement. And say that if he doesn't do so, he says that it will be done. If
Yes,
he
ma'am.
doesn't do so, you are at liberty to file a separate writ petition. Then
Right.
there has to be a direction against them.
Yes,
Those
ma'am.
on right.
Now, as it now, the PWD has done it. Now, if
Mhm.
we see that particular judgment of the Supreme Court in by Justice Gauhati and Justice Masi, it has been categorically mentioned that there cannot be a willful and deliberate violation on the part of the PWD. because of the fact that the PWD has already done their part. They have deposited because that was the law at
Yes.
that point, or at least the understanding of the law. Until there is a judgment passed by a coordinate bench of this court holding that now you cannot take that amount which is there, it has to be refunded by the PWD. Now the PWD says that, okay, we can refund, but we don't have the money. The money we have already given to the forest department. Because at the end of the day, the deduction was not for themselves.
Yes.
Yes, sir.
The deduction is from them. Now, just for example, let us take a very simple example. You are a taxpayer,
Right.
okay? Now, when you are a taxpayer, income taxpayer, you purchase something or you get the fees from your client. The client says that we have deposited the amount in the income tax 194. They will deduct it. They have deducted it. Thereupon they deposited before the income tax department. Now the income tax department does not provide the refund. The deduction may be bad, but the income tax, therefore, you are not liable for tax. But therefore, the tax was there. But there has been a deduction. The deduction now is with the income tax department. Are you going to file the case against him or the income tax department?
Income taxes.
So therefore, we close these contempt petitions against the PWD
Yes.
and taking him that his submission to that effect that they are taking now analyzing and making the computation and submits that they would be doing it. We close this contempt, liberty given to you to file petition against this petitioner, the forest department, if they don't do with this.
My lord.
End of the.
Good for everybody.
That can be done, Lordship.
Heard, miss, because otherwise this is not going to end this way. File a petition, then we can take it. What do you say, Mr. Advocate General, Additional Advocate General? Sometimes I forget taking into account the so many cases you handle, whether you are the Advocate General or the Additional.
These are statutory deductions, my lord. So we have deposited in the.
So you have done it.
Yes.
So you have done it and deposited it. There is no quarrel with that proposition. So therefore, the contempt qua you does not really lie. As regards the forest, he appears out there and he says that they are checking out from the treasury and they will be doing it. Heard Mr. R.M. Decker, the learned counsel, appearing in the present batch of contempt applications. Mr. B. Gogoi, the learned additional advocate general. Anna, you are appearing for these contempt now.
Yes, sir. Respond. LS contempt.
And who on earth have made the Gauhati Municipal Corporation as a party
No, contrary.
in a contempt? If I am not wrong,
We don't think it's.
oh no, they have wrongly mentioned. See, the cover is Gauhati Municipal Corporation and two others. Appears Mr. B. Gogoi, the learned counsel, appears on behalf of the respondents in the various contempt applications. Pursuant to now, where does the forest come into the picture?
My lord, the writ petition states the forest department was not the party, my lord.
Understood. How does he come to the picture now?
After the submission made by the PWD that the.
Now, how is he now into this picture? Is he a party?
Yes, ma'am. There is no, he's not
Not
a
the
party,
party.
but there is a direction of the honorable court whereby the forest department was directed to look into the issue.
Okay.
Considering. all this.
Mm.
Mr.
right? Order dated 18/2/2026, Forest Department came into the
18,
in 385 of 2018. Sometime case 385 of 2018. Order dated 18/2/2026,
18 to 26.
paragraph 5.
Mr. R.R. Gogoi appears on behalf of the Forest Department of the Government of Assam. The present batch of contempt applications arises out of various orders passed by the learned coordinate benches directing the PWD Department of the Government of Assam holding inter alia various orders passed by the learned coordinate benches holding inter alia that the deduction of forest royalty by the PWD department was not permissible, and accordingly directed the PWD department to take steps for refund of the said amounts deducted within the periods mentioned in the said orders. The petitioner herein who has filed this batch of contempt applications is aggrieved by the inaction, is aggrieved, have alleged that the PWD department there has been willful and deliberate violation to the various orders passed by this court, thereby not refunding to the petitioner the forest royalty which have been paid by the petitioner, which were deducted from the
Deducted.
petitioner by the PWD department. The PWD department appearing through Mr. B. Gogoi appearing on behalf of the various officials of the PWD department submits that the deductions of forest royalty was carried out on the basis of Rule 5, na? Rule 5?
Rule 5.
Rule 5 of the Assam Minor Mineral Rules 2013. And thereupon, the said amounts have been deposited in the treasury in the head of account of the forest department. He therefore submits that though the PWD department can only provide details as regards the amount of deductions which were carried out, but for the purpose of refund, the same has to be done only by the forest department. This court takes note of an order passed by the learned coordinate bench dated 18/2/2026, whereby the forest department of the government of Assam was roped in to obtain instructions as to why in the present proceedings to obtain instructions as to why the forest department have not refunded the dues to which the petitioners are entitled to which the petitioner is entitled to on account of refund. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Forest Department, submitted that all these amount that deduction of on account of forest royalty carried out by the PWD department is not only limited to the present batch of proceedings. Full stop. And the full stop. The learned counsel further submitted that upon deduction being carried out by the PWD department, PWD, the same were deposited in the head of account of the forest department. And necessary verifications are still being carried out. The learned counsel on instruction submits that upon necessary verifications being carried out, the forest department would refund the amount to the petitioners, to which the petitioners are entitled to the petitioner to which the petitioner is entitled to. Taking into account the issues involved in the present batch of contempt applications, it is the opinion of this court that the officials of the PWD department cannot be held to be in willful or deliberate violation to the orders passed by the learned coordinate benches in the various writ petitions. Inasmuch as it is outside, it is beyond the capacity of the PWD officials of the PWD to refund the said amounts, as the said amounts are lying with the forest department. Considering the above, this court therefore drops the present batch of contempt applications. This court, however, finds it pertinent to observe that the present batch of the contempt proceedings have been dropped on an assurance given by the forest department that upon due verification, the said amounts would be paid, amounts to which the petitioner is entitled to on account of refund would be paid. Considering the above, it is therefore observed that the closure of the present contempt application shall not prejudice or preclude the petitioner to again approach this court by filing the writ petition in the circumstance the entitled amounts to which the petition in the circumstance, if the entitled amounts of refunds are not paid to the petitioner, are not refunded to the petitioner by the forest department within a period of 6 months from today.
Item number 8, madam, I put the instruction that, madam, because there was an interim order pending, no deduction was made till the date of payment of the final bill. So perhaps, madam, refund doesn't arise in item number 8.
Item number
Yes,
8.
that is my instruction. So that they will verify that also. Lordship will kindly indicate in the order. Item number 8.
Item number 8.
4/1 of 2018.
Yes, sir.
411.
No, you see, you have verified. You inform it to him.
Lordship will reflect it in the order because.
No.
We have not
One line it is there.
Only
I
one
no, I will put another. It's dropped. It's dropped. Full stop. Then stop. Full stop. This court, however, directs dropped off issue. This court, however, directs the PWD to provide an accurate list
Yeah.
upon due verification of the amount so deducted from the petitioners, which are the subject matters of the present contempt applications to the Forest Department, so that the Forest Department can arrive at, is able to determine the amount which is required to be refunded to the petitioner.
Including,
That I'm putting it.
including the head of account, because different head of accounts are there, your lordship,
in different districts.
different districts.
In addition to that, the PWD department shall also provide the amounts that the deposits so made in the respective head of account
Yes,
of the Forest Department.
Deeply obliged.
obliged, lordship.
Therefore, I'm not recording that thing, because why I'm not recording is then again it comes something else. It becomes a difficult proposition. So I put it everything, now you do it. There will be subject, these directions, I'll make it very clear to that. I'll make it more finer.
Mine.
Obliged.
Yes. Assembly session, the needful could not be done.
Well, the sanction from the finance department has been received. Sanction from the finance department has been received by the DC, my lord. I'm informed today. They need some 1 week, within 1 week time, possibly it will be released, my lord.
Disperse. How much is the amount?
Amount is 6 lakhs, my lord. 6 lakhs 21,800.
21,000. You got the finance approval?
Telephonic information I have.
Mr. Dina, the learned counsel appearing on behalf of the district commissioner, Morigao, submits that the financial approval have been granted by the finance department of the government of Assam. And within 1 week's time, the said amount would be disbursed to the petitioner's account.
Lodge.
The entitlement of the petitioner would be disbursed. So considering the above, list this matter on 11th of September 2026 for an update.
Lodge.
Wait, please, Your Lordship.
Yes,
But
what
that-
is this?
Affidavit
Contempt
in
so
oppo-
big.
Affidavit in opposition has been filed. These are
What
the
is this?
affidavit in opposition. My
You have made this contempt something different. What is this contempt?
lord, this is not the contempt, my lord. Affidavit in opposition, these are
Oh, affidavit in opposition, my goodness.
3 persons.
What
So,
is
my
the
lord, my
direction?
humble submission, my lord, I am to file a reply.
Understood, but what is the reply? What is the contempt?
They said, my lord, that they were dispossessed. There was an interim order passed by this honorable court. But nonetheless, the petitioners were dispossessed.
Mm.
We have categorically stated, my lord, that the
Eviction was duly carried out. on
Yes,
6/1
already
today
my-
at
the
7:30
eviction was
AM
carried-
and
Your
was
lordship would be
completed by
pleased
as
to
stated and
turn
have
to
be-
page
If the
15.
eviction is carried out as stated here, the respondents will ensure are granted all facilities and privileges which are prescribed under the year. Now,
My lord,
what is
your
the
lordship-
injunction?
What is the order, my lord? Your order, your lordship would be pleased to see page 15.
Page,
Page 15.
no, page 21.
Yes, my lord.
So they say that they have evicted you at 7:30 in the morning.
My lord, what happened, my lord? They said that we have been evicted. But thing is this, my lord, your lordship passed an order on 6/1/2026 that no further action will be taken on the land. That is the order.
Where?
That is at page 15, my lord.
Where is the order?
Relevant portion, my lord, your lordship at page from 18 onwards,
Huh?
from page 18,
No, forget about that. Where is the direction?
my lord. Your lordship will turn to page 22.
Yes, where is that?
12, para 12.
I've read it. Where is it?
Yes. Now what happened,
Will
my lord?
not take any further steps in respect to this land till the next date fixed.
So, my lord, we, after eviction, my lord, we constructed some temporary sheds on the house, temporary sheds in the land. And what happened, my lord? No further action will be taken on the land. That was the observation. And that interim order was continued till date, my lord. But they
Where is
have,
the writ petition, Mr. Counsel?
Petition is not listed today.
Okay, we'll list there and finish it off. And
Absolutely.
that order should not have been passed by the learned coordinate bench. Because of the fact that on one hand, means what is his contempt? This contempt is an encourages contempt. First you evict him, then goes inside. And there is a direction passed by this court to the effect that the authorities shall not do anything. Meaning, you evict, then nothing happens.
no, my lord, regarding this, my lord, your lordship, when your lordship will see the writ petition, my lord.
Position of status quo
My lord.
ante has been diluted. It is a case of.
You cannot construct thereafter, after you being evicted.
Absolutely.
This was never a subject
Your
of
lordship,
consideration.
your lordship
Anyway,
would be
we
pleased
do one thing. We list the writ petition and finish up the writ petition and this one.
along with, yes, my lord.
On an earlier occasion, Lordship has passed a direction for listing, my lord, all these matters together. I
Then
don't
what
know-
happened?
Yes, my lord, I don't know why this, or only the contempt is listed today.
Okay.
It may be on, my lord.
Because Mr. Sheikh, what you are submitting is absolutely not permissible.
Eight or nine, my lord.
Yo, after this order, if you have done anything, this order would have no effect.
Let
It's
this,
a subsequent cause of action.
my lord, your lordship would be pleased to see, our contention is this, we are illegally evicted, my lord.
What do you mean?
My lord.
But you were evicted.
And another thing is this, my lord, as per clause, General Clauses Act, my lord, that they will give me 3 days time. And they issued the notice on 3 and evicted on 6. That is also a clear violation of their eviction notice itself. These things are there, my lord. Let the writ petition counsel this.
Yes.
Yes,
These are
my lord.
matters to be agitated in the writ petition, my lord.
Huh?
These are the matters to be agitated in the writ petition.
That is why, my lord, that writ petition will come
But
along with
contempt
it.
petition-
We will bring the writ petition.
Yeah.
Yes.
On 8, my lord.
For the purpose of deciding the present contempt application, it is the opinion of this court that the writ petition being WPC number, what is the WPC number?
93, my lord, 93 of 2026.
93/2026 is required. Accordingly, list this matter again on when?
8, my lord. 8 or 9.
9th of September 2026, along with WPC number switch.
My lord, there is a miscase also, my lord, along with this miscase.
What miscase?
Miscase in the writ petition, my lord.
Miscase will come.
Yes, my lord. Oblige, your lordship.
In the
And
meantime,
so-
the petitioner would be at liberty to file any reply to this affidavit.
May it please your lordship, proceed, I have received instruction, my lord.
Okay, so the certificate. Yes, have you paid the amount?
Lordship, the second paragraph, my lord, this amount has been,
The computer author has recorded
Approval has been
approval of
given.
the Iman and the proposal has been submitted online to the finance department for adoption of.
lordship may kindly grant us 4 weeks time. In the meantime, it
Don't
will.
worry, don't worry. Give a lot of time. Pursuant to the order dated 27/2026, Miss M.D. Bora, the learned standing counsel of the Transport Department, have provided an instruction issued by the Director, Inland Water Transport, wherein it is mentioned that that the competent authority had already accorded approval to the CF proposal on 14/8/2026. And the proposal have been submitted online to the Finance Department through the Fin Assam portal for allotment of the requisite funds. Upon receiving the necessary sanction from the finance department, amount would be released to the petitioner. Full stop. The said instruction is kept on record and marked with the letter X. List this matter again on 9th of October 2026. In the meantime, the respondents shall take effective steps for release of the amount.
Your Lordship.
No, I paying for the Mapam Municipal Board, my lord. We are yet to receive the records, my lord.
Yes, what is this?
Lordship, the petitioner, private respondent number 5 was uh, allowed to participate in the financial bid, although he did not qualify the prescribed mandatory eligibility qualifications. Lordship.
Mr. Asana?
Letter of intent was issued.
No, madam.
So I have stopped issuance of the letter of intent. Now what has happened? What do you want?
I need some time, madam. At least, madam, 15 days, madam.
And as regards the respondent, private respondent is represented. Is your affidavit of service?
Lordship, we have taken step by register post and dusty service also we have done. We have filed an affidavit, Lordship.
Who is Papu Ghosh?
Lordship, his driver, we have given
Huh?
the phone number.
No service. Driver cannot.
We'll take fresh step. Lordship, we have taken
We
two attempts.
vacate the interim order.
Lordship, we have made 2 times attempt. He was only available. That's why we have given the phone number and we have taken steps by
You
way of
cannot
register
give it
post.
to the driver.
Lordship,
Driver is no service.
Lordship, we have categorically stated that
Mr. S. Bottakor appearing on behalf of the respondents.
Four, madam.
Numbers,
Four, madam.
respondent number 4 submits that he requires some more time for filing an affidavit in opposition. This court have also taken note of that the service in respect to the respondent number 5. It appears therefore that till date, the service by way of speed post have not yet been effected upon the respondent number 5. In addition to that, this court have also taken note of the affidavit of service so filed by the petitioner. Upon being asked as to who is Papu Ghosh, upon whom the service was meted out on behalf of the respondent number 5, Mr. G. Khandelia, the learned counsel appearing on behalf of the petitioner, submits that Mr. Sri Papu Ghosh is the driver of the respondent number 5. In the opinion of this court, the same cannot be treated to be an adequate service by way of dusty. Accordingly, this court therefore directs the petitioner to take fresh steps upon the respondent number 5 by way of dusty, routed through the registry of court and file an affidavit of service on or before the next date. List this matter, how much time?
15 days time, madam.
On 25th of September 2026. In the meantime, the respondent number 4 shall bring on record its stand by filing the affidavit on or before 22nd of September 2026. The interim order passed earlier shall continue till the next date.
much obliged. Lordship.
তাতে আৰু এটা লিখি দিবা। Interim order. It is also being submitted by Mr. S. Bottakor, the learned counsel appearing on behalf of the respondent number 4, that till date, neither any letter of acceptance nor letter of intent nor any agreement have been entered into with the respondent number 5. Under such circumstances, the interim order passed earlier shall continue till the next date.
Much.
What is this?
I have challenged the settlement order of industry respondent number 7,
Hmm.
and your lordship by order dated 14/8 pass an interim order.
Hmm.
Thereby restrain.
What is your instruction?
Lordship, will file affidavit, Lordship.
You file?
No, we will file.
Have you
For
guys,
that, 3 weeks time is required.
now have you granted the
direct-
settlement in so and so
No,
for a
we-
year or a year state?
No, Lordship. There was interim order passed by dishonorable court.
So you have
we
not, but you are running it by yourself.
Yes.
What about the service upon the respondent number 7?
Seven, you have also directed to take Dosti service, complete, I have filed also affidavit, it is not in record. Comply with that.
You have served it. Oh. This court duly takes note of. And Miss N. Chaudhary, the learned counsel, standing counsel of the BTC, submits that some more time is required for filing the affidavit. This matter on 28 September 2026. Interim order passed earlier, stand shall continue till the next date. Next, that was the. This court have also taken note of the affidavit of Dusty, so filed by the petitioner. You have filed?
No, filed it, yesterday filed it.
Filed by the petitioner. And from a perusal of the said affidavit, it is apparent that the service have been meted out upon the respondent number 7. Accordingly, the service upon the respondent number 7 is deemed to be complete. List this matter for admission on so and so. List accordingly for admission. Interim order passed earlier shall continue till the next. এখন ঘুরাই দিব তো।
May I please, your lordship? Lordship, my senior on next in another court, kindly take this matter after some time.
What is your contempt?
So,
Yes. Where is Mr. D. Nath? He is expert in this type of matters. Yes, Mr. D. Nath. Hey, give a copy of the petition. You have a copy of the petition or not?
I'm,
Lordship, IA.
Forget about I.
my copy of the petition is on my sir. Sir is on another court.
What? Yes, sir.
My senior
can't do that.
is in another court.
He is not fit for this type of matters. Hey, Kondo. I'm calling you because you seem to be expert in this field. Isn't it? Mr. Nath,
No,
are you not expert on this?
no,
field?
I'm not
Huh?
expert. I'm not expert, but I have come across 2-3 matters. I'm
You do one thing. You
What?
obtain instructions
Mal.
on the aspect because I think here also the circle officer will come into the picture.
Lodge. I
They have again given it to the district commissioner.
group matter.
Otherwise, his contempt does not lie, but the circle officer should have been there. Now, whom are you trying to make a part? Again, the district commissioner. These have no business out there. You see, in Borpeta, it is the circle officer. Contempt. এইটো কোনটো লৈ আছো মই contempt টো লৈ আছো এইটো item 22 which item 22 yes you come Yeah, why you are making him a party?
My lordship,
You see, the designated public servant is the circle officer.
yes,
Now, is circle officer a party or not?
yes, party in the contemplation, my lord.
Is a party.
Party.
Then why you need the DC? There's
You
the
need-
direction only to the designated public servant.
My lordship, earlier this district commissioner has been transferred, my lordship.
Understood, but why? See the direction passed by the learned coordinate bench. ए फाइल को इनके भूल भूल के दिए क्यों? फाइल तो ना पूरे दी थी फाइल को दी थी. Your matter is, wait, my office is in a shambles. Your contempt, wait, don't disturb. Contempt case 254/2026.
Yes, my lord.
You had
And-
filed an IA of 2894/2026.
Yes, my lord.
Fantastic. Now tell me, in this judgment,
Yes,
for non-compliance, you are filing it?
yes, my lord.
Direction is to whom?
Designated public servant,
Who is the designated public servant?
circle officer.
Why are you making the DC a party?
This is the senior authority.
So what?
commissioner.
The direction is only to the designated public servant. Liberty to place, see, kindly see, paragraph 32.
32, yes, my
The
lord.
impugn order of rejection has been set aside. The designated is now required
Yes,
to consider the application submitted by the petitioner for notifying Iman. Composite shall strictly in so and so as amended along with other binding decisions in the connection, and thereafter to pass a speaking and reasoned order within 45 days from the date of submission of a copy of this order by the petitioner before the designated public servant.
Yes, my lord.
The designated public servant is to carry out. Why the DC has to be brought in? The
This is-
designated public servant has been already delegated by the deputy commissioner to be the circle officer.
Yes.
So the DC has no business out. Why you are making the revenue a party? You don't make the revenue a party.
Because my lordship,
You are violating. This is the problem of
By-
our courts. Notices are issued just for the sake of it.
in the writ petition, my
That is
lordship.
why our notices of contempt are not being given importance.
Yes, my lord.
You don't issue a notice just for the sake of it. Here, the direction is to the designated public servant. The designated public servant is the circle officer. There cannot therefore be issuance of notice upon the secretary of the revenue department or the DC.
Yeah.
We strike them, both of them.
Okay, we'll file a fresh.
No, not necessary. We'll take care of that.
Okay, my lordship.
Mr. Nath is there to take care of. This is an application file alleging willful and deliberate violation to the order dated 26/8/2025, passed in WPC number 2340/2025. Paragraph 32 and 33 of the said judgment order being relevant is reproduced hereinunder. From a perusal of the same order, above quoted directions, it is apparent that the direction is only against the designated public servant. The designated public servant in respect to Mr. Nath, what is that? Mr.
NOC.
Nath, in respect to what matters?
That is-
You showed me that in Borpeta town that
No,
notary.
no, that is in respect of Sri Bhumi, my lord. I have shown your lordship in respect of Sri Bhumi.
Sri Bhumi, but you have appointed whom? Borpeta also there is another case. Mr. K. Gogoi was appearing in that matter.
Post office there.
You remember that case? Another
I-
case where I have asked the DC to appear in another case.
I remember he informed me.
Hmm. There also, it is the circle officer.
If it is circle officer there, then circle officer has to know.
I remember because Mr. K. Gogoi was appearing
Yes,
in
yes.
that.
Mr. Gogoi has informed me that this problem has happened there also.
You do one thing,
My lord,
you just get the inquiry and
my lord,
and accordingly we strike off whoever they.
my lord.
So and so, the designated public servant, the above directions would show that the direction is only against the designated public servant. First, insofar as matters pertaining to permissions, NOCs for land transfer, the designated public servant is the circle of officer of the concerned revenue circle in the district of Borpeta. আৰু যদি এওঁ আনি পেলাই কয় DC হয়, then DC কৰি।
I'll come back.
Under such circumstances, there is no requirement of the respondent number. There is no requirement. Under such circumstances, there cannot be a question of any willful or deliberate violation by the respondent number 1 and 2. আৰু যদি DC হয়, respondent number 1 and 3. Accordingly, the names of the respondent number 1 and 2 are struck off. And the respondent number 3 would become the sole respondent. আৰু যদি DC হয়, respondent number 2 becomes the so and so. The legal counsel appearing on behalf of the parties, further to that, the present contempt proceeding stands dropped qua the respondent number 1 and 2. The learned counsel for the petitioner shall file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order, as well as it is a decision hoy, as well as the order passed in so and so, shall make necessary changes in the cause title and update the same in the CIS. This court have requested Mr. D. Nath, the learned senior government advocate, to obtain instruction as to whether the judgment and order dated so and so, passed in so and so, have been complied with by the sole respondent. The name of Mr. D. Nath be shown in the cause list by passing a speaking order. The name of Mr. D. Nath be shown in the cause list. A copy of the contempt application be served upon Mr. D. Nath, the learned senior government advocate. List this matter again on 11th of September 2026 for an update.
Not.
Yes, cause list time. আৰু ইখন এলাও কৰি দিব যদি DC হয়, নহলে যদি DC নহয়, circle officer হয়, তেতিয়া ক'ব the instant application is infructuous, is misconceived, for which the same is rejected. Mr. Borpuzari, you appear. Say that R1 is, he has nothing to do in view of the directions, the submission of item.
There were two connected matters, item 22, 23.
Similar matter, my lordship.
Same.
Same.
Both Borpeta,
Borbata, similar matter, my lordship.
Similar.
Borbata.
same order type.
It's also the same.
Plus.
Item 21 now. Alena file 2. 21 to do. 22 and 23 here whole 21 to good goal.
My lord, this is an application for implement of parties, my lord.
Why?
My lord, the eviction notice was issued against the petitioner, my lord.
Why?
The petitioner has entered into an agreement for sale with his vendor, my lord, Bolendranath Thakuria. Due to some bona fide mistake, my lord, he was not made party in this writ petition, my lord. That is why by order dated 29/7, I was granted some 2 weeks time to file appropriate application at page 16, my lord.
Tribal belt.
My lord,
Tribal belt.
Tribal belt, my lord.
So,
But my lord, my predecessor was also in the possession of the tribal belt, my lord.
tribal belt, I passed various orders. Why should we entertain? Whether you were tribal belt or not,
My lord,
you are not a tribal.
my grandfathers were from since 1948. They were possessing the land, my lord.
Who?
My grandfathers, my lord.
How do you know?
My lord.
You are possessing the land, not even purchasing the land.
Purchasing, my lord, their name were mutated. Your lordship will find in the writ petition, my lord. It may be considered that on.
So there is an agreement for sale.
Yes, my lord.
Agreement for sale in the month of November.
November, my lord.
How does this happen? How can there be a sale of a tribal belt land to you?
But that is why, my lord, the eviction notice was issued against the possessor, my lord, not against the, my lord, owner of the land, my lord. That is why I have challenged the eviction order notice, my lord.
Who is the owner?
Owner is the, my lord, the Bolendra Sondra Thakuria.
Who is the owner? Who is possessing?
I am possessing, my lord.
Obviously, you have to be thrown out. Rightly so.
The lordship is the writ petition, my lord.
No. You don't have any right to remain in tribal land.
Lordship
should
may,
we
lordship may
interfere?
decide the point in the writ
Yes,
petition on
forest the
28th, my lord.
revenue is there. What is your instructions? You are taking this matter very lightly. There's a stay.
Stay is there, my lord.
Stay is there. Then it seems that you are not interested. Then
Writ petition is fixed on, my lord, 28/8/26.
today is what?
It is, my lord, 26th.
Why did you file this application?
My lord,
Bringing it before this court unnecessarily to get a dismissal.
my lord, this I may not be.
You have no business. You have no right. The land belongs to somebody else. Who are you? Your agreement for sale is entered into in 2025. Where is Mr. Arbor Pujari? You ask him to come. You don't know what is happening. What about the tribal belt lands? What has happened to those batch of writ petitions? There were many challenges made to the tribal belt lands. Here is a case the petitioner is claiming. I would have understood this Bolen Thakuria coming in
My
as
lord.
a writ petitioner.
My lord.
But who are you? You only have come in on the November 25.
My lord,
And you want to make him what? A co-petitioner
what happened?
or a respondent?
My lord, what happened, my lord? My grandparents were the inhabitants of that, my lord, tribal belt, my lord.
So what?
I have inherited property.
As
from
of
grandfather.
now also you don't have a, what do you call, sale it.
My lord, that may be decided on 28th, my lord.
Just now. Today I have not been able to decide any writ petitions. This is the mail. We finish it off right. You made a mistake.
On 28th then, my
If it
lord.
was on 28, it would have come before the other kind courts.
Then, my lord, 28th, on 28th. my
Then
lord.
28. There cannot be a stay. You have no business out here.
Then 28th, my lord.
And anyways, the forest, this department is here. But why do you want to make him a party?
But as per order dated 27, my lord. Page 16, my lord.
Where? You have no business. And you are taking it very lightly, revenue, as well as the district administration, who have issued this notice. You have taken it very lightly. We do one thing, continue the stay order sine die. Any matter would not come unless and until you have any instructions. We continue the interim order. The matter would not be listed any further. Interim order will continue till the disposal of the writ petition. And the revenue shall not under no circumstances be permitted to take any steps for eviction. Fantastic orders. in spite of a stay order passed by this court on 29/7/2026, the respondents, both in the district administration as well as the revenue department, have not provided any instructions. There's also a stay order passed by the learned bench of this court. There's also a stay order that the petitioner shall not be evicted in connection with the subject plots till the returnable date. So taking into account that the respondents in the district administration as well as the revenue department are least bothered in spite of a stay order being passed, this court extends the interim order passed on 29/7/2026 till the next date. This matter on 29th of January 2026. Interim orders passed earlier. Full stop. In the meantime, the respondents would be at liberty to bring on record the so taking icon. Here, where is the direction passed by this court that he should be made a party?
Lord, on page 16, my lord, subclause 6, my lord, Mr. Chaudhary has submitted that he will file appropriate pleading for implement of the landowner of the subject plot within 2 weeks' time.
Why do you need the landowner?
Because, my lord, the honorable court has, my lord, asked that as the landowner is not a party, my lord, the eviction order against the possessor may not be issued, my lord, by the authorities.
But he has to be a petitioner. But he cannot be you are asking him to be made a respondent.
My lord, the state has objected, my lord, as the
Obviously, you can't make him a petitioner respondent. You have to make him a petitioner. So your petition is wrong. Now you cannot do it. He has to file an application.
because my lord, eviction order was passed against me, my lord.
So now I'm extending it till January.
My lord.
They are not going to do. And once this order is passed, you may there for another 10 years. No worry. You want that order also that in the meantime permission should be granted for sale? We can give that also. Is an application filed for impleading the opposite party number 5 as a respondent number 5 in the petition. It is relevant to take note of that the opposite party number 5 is admittedly the landowner wherein the petitioner / the applicant is residing. In the instant case, in the opinion of this court, that the instant application is misconceived. In as much as the opposite party number 5 cannot be impleaded as a respondent in the instant proceedings. He can only be at best, the opposite party number 5 can file an application, separate application, seeking impleadment as a petitioner, co-petitioner. Accordingly, the instant application stands closed as is rejected as misconceived. So tribal belt, this has gone for a 6. No instructions. You got to stay also. A person who is not even a petitioner, who is not the landowner, also you can't evict. This is the means you are not serious. It seems that you are picking and choosing some persons.
Series of communication. From our side.
We made it after, fixed it on 29th of January.
I was led by I Chaudhary, my lord, but due to suddenly he had to leave. I'll be addressing your lordship, my lord. On
What happened to I Chaudhary?
he had to suddenly leave to Arunachal Pradesh, my lord.
What is your case?
My lord, pursuant to a valid tender process, my lord, I was allotted the contract. For,
I have two writ petitions.
this is the offshoot of the first writ petition, my lord, item 24 and 25.
Okay, let us
25 was,
take the main writ petition, 2013 writ.
if your lordship takes 5943, my lord, that will have all the facts, my lord.
No, let us take the first one. If we can finish up the first one, then the offshoot doesn't have anything. What is your case?
Your lordship, please. I'll just. Now, my lord, on 39/2008, and work was allotted to me, my lord, which your lordship will find at page 19.
Then what happened?
Thereafter, my lord, they terminated my work.
Yeah.
I came before your lordship. When I came before your lordship, my lord, they filed an affidavit in this matter, 2515. It's a part of the record, wherein they had stated that the balance work has been, my lord, pursuant to a tender. They have floated a tender for the balance work, and they have, my lord, ousted me from the work. And in that affidavit, my lord, although they have stated, if your lordship has the affidavit,
No,
they have
no, you
stated that
tell
they have
me what has happened thereafter.
paper publication. Subsequently, my lord, we discovered that the statements so made in this affidavit were actually false statements on oath, my lord. Through RTI and various other means, my lord, we had gathered information. And we came before your lordship by way of a review petition. And by way of that review petition, my lord, this original writ petition was revived. This was actually disposed of at one point of time, my lord.
What is this? In view of the above writ petition, dispose directed to dispose of the further appeal that has been prepared by so and the petitioner was to nominate his own representative towards the disposal. In disposal of the appeal, the bank guarantee is deposited by the petitioner and may not be now shall be extended.
And that is how it has come before your
Now the
lordship.
bank guarantee has been extended.
Bank guarantee, my lord, they have liquidated everything, my lord, even for works which
Now, my question is, has the bank guarantee been liquidated or not?
liquidated.
So they have invoked it. So nothing remains there. Now, as regards the work, what is your prayer? Let's see.
My lord will kindly see my prayer at page number 16. Page number 16, in fact, may I just read out at the bottom, my lord. In the premises aforesaid, your lordship may be graciously be pleased to admit this petition called for the by cancelling the impugned NIT issued by the superintendent engineer and setting aside the cancellation of work order dated 3/12/2012. So
Are you going to do the work now?
because the work is already over.
So nothing remains in the petition. We close it.
Yes. But only thing is there, my lord,
Wait.
this challenge to their termination, my lord, 3/12/2012. That is a wrong, I mean, that is on the basis of this termination, I was issued another letter by the department stating that an astronomical amount of, my lord, rupees 1 crore or something has been due from me. So that is why this cancellation prayer, if your lordship holds that this cancellation is wrong or illegal, then my lord, my second writ petition will be allowed.
Why should I hold the cancellation to be illegal?
Because
Cancellation has already been done. There is a subject matter of other proceedings. Why haven't you gone there?
we've gone.
The cancellation happened or not?
Cancel.
All understood. Forget about the short tender notice and all. First prayer of short tender notice goes.
It's gone.
Secondly, as regards the cancellation was
Termination.
made in 2012.
2012, my lord.
So therefore, my question is, once the short tender notice was, this particular notice, what are the prayer? First is short tender notice. This has
Yes.
become infructuous. The letter of acceptance dated so and so, given to somebody else,
That
it
is
has become infructuous.
infructuous.
Setting aside the letter of cancellation of work issued by EI and directing not to further proceed to withdrawing the so and so. Performance guarantee done.
Done. But only thing
Then the
remains
cancellation of the work order has been given.
cancellation.
Now, once it has been cancellation, have you challenged the termination?
Yes, my lord.
Where?
this is the termination, my lord. This 3/12/2012.
Okay, what is your ground of termination?
My lord, there are various grounds, my lord.
What are the grounds? One ground will do.
First of all, my lord, this termination was done to, my lord, illegally oust me to favor the private respondents, private contractors. That is the number one ground, my lord. And as has been apparent from the records, my lord,
Let's see that the cancellation order.
cancellation, my lord,
Is 40.
page number 40, my lord. Page 40, my lord.
Whereas the above work has been awarded where you fail to perform as per clause 21 of the contract of the so and so and thereby fail to achieve the milestones. So
And at the bottom.
the moment the question of milestones come, the question is a question of fact. Now, whether it is true or wrong, it is absolutely a disputed question which needs to be adjudicated.
Correct, my lord.
Now, we can very well do one thing to the effect without going into it, that this period is there, whatever may be. If you want to challenge the termination, you can do it before any other forum, not here.
I just want to
dispute
point
the
out one admitted fact from this page 40. Kindly see at the bottom who has issued this termination, my lord.
Hmm.
It's an executive engineer, PWD, my lord.
Hmm.
Under the contract data, my lord, he is not authorized. The jurisdiction is vested on the chief engineer as per the general conditions of contract which was entered
But
between
did the
this.
court stay?
My lord,
Did the court stay the termination?
no, court did not stay. Court had this
Then the question is, once the termination has happened,
termination is happened.
termination has been done. So it is an illegal termination. If it is an illegal termination, the question is for breach of damages. There's nothing else. I can't help you with this. Read court can't do anything.
Because the
Damages.
because my lord, under the contract data, my lord, this executive engineer has absolutely no role to play, my lord. He has no jurisdiction at all. That is,
Then upon, did you, on the basis of this contract, carry out the work?
I carried out the work. There was a remaining small amount of work which was remaining. That work, what they did, they floated a fake NIT and they distributed it to certain, my lord, blue-eyed contractors, and they ousted me from the work. And the blue-eyed contractors, they finished the work, my lord.
Therefore, the question is, did you carry out the work without recognizing that this is the termination?
No, once terminated, my lord, I
So
could not.
if you have acknowledged that the termination, meaning do you have acknowledged the authority of termination?
No, I did not acknowledge, my lord. That is the reason why I challenged it before this honorable court, my lord. That is
So
the
you have not completed the work.
that remaining portion I could not, because of certain, my lord, I'll place from the record, because of certain conditions which were prevailing. And I had pointed it out to the authorities. Their own executive engineer had submitted an FIR before the SP, the concerned SP, stating that, my lord, kindly provide security at site and everything, my lord. So this termination is bad in law, my lord. That is what I'm trying to impress upon your lordship.
Understood. If it is bad in law, it is a case of damages. You have not been, on the basis of this document, you could not carry out the work.
I could not carry out the work.
Therefore, your termination is bad. Nothing more than that.
Your lordship is right.
And thereby, for that, you could not reap the benefits which you could have earned had the
Yes.
termination not been done.
Your lord,
Now, in the instant case, the termination was done by an authority who was not empowered and would not do alone. You have to also show that you have been stopped from doing it.
and my lord, your lordship is absolutely on the point when your lordship says that this regarding this part will damages is the way out. But my lord, what they had done using this termination, my lord, they have stopped payments of the bills of all other works which have successfully completed with completion certificates. On the basis of this termination, my lord, even those money, my lord, they have, my lord, kept it away from me.
So why, if those are there, why you have not challenged it?
I have challenged. That is the subject matter of the item, what's this, 24.
Understood, but that is a challenge. How read courts will look into it?
My lord, I can satisfy your lordship, my lord.
Please do so.
If your lordship kindly takes up the,
So therefore, this case has no business with that.
your lordship will hear item, my lord, 20.
I'm hearing only. What am I doing?
May I just point out item 24, my lord?
Yes.
Kindly have a look at item 24.
What are you challenging?
Item 24, my lord.
Read in the nature of surgery not to be set aside and quash the order bearing number so and so of 2013. What is this order of 20?
This is that order of the that alternate dispute resolution. Against the cancellation, I had gone for that. There's an interdepartmental appeal that under clause 24.1 before the GCC. Even that was rejected. Subsequently, there's an appeal before the standard empowered committee. Even that was rejected. So all these rejection orders have been challenged before this honorable court. And there is a letter dated 14/8/2015, which your lordship will find at page 97, my lord. Page 97. They suddenly give me this letter, and at page 99, the relevant portion, your lordship will see at the bottom. Therefore, it is certified that Shri so-and-so contractor is liable to pay a sum of rupees 1,11,16,130 rupees, which is debt payable to the employer. This is a finding they come without, my lord.
This is on 28/1/2013.
No, but this,
21/2000, page 99.
my lord, communicated on 14/8, page 97. Kindly see 97, my lord.
It has been communicated on.
So,
in
so
14.
they say payment upon termination of package number so and so. This is the decision, and they've enclosed that certificate. They do not give it to me immediately. They give it after a long time, my lord. So this is the third
This
challenge,
you have put to challenge.
my lord.
You have put to challenge here.
I have put to challenge, my lord. And apart from that, my
Where is
lord,
your challenge?
pay,
That one,
That one.
C.
see, my lord. And the next prayer is, my lord, with regard to the release of payments. For your lordship's convenience, I have made a chart at page 39.
What are these judgments? Long judgments?
These are all the orders passed by this honorable court in the previous litigations, my lord.
There's a contempt file
Contempt was filed.
initiated.
Criminal contempt because of the false affidavits which were filed before this honorable court. They went to an appeal. The appellate court dropped the contempt because they tendered an unconditional apology, but the other things remain. The rest remains. If I may just place the facts chronologically, my lord, one by one.
Yes, what is your stand now?
My lord, the work order was issued in 2008, my lord. Till the date of my lord termination, only my lord 40% was completed. For that reason, my lord, after issuing two so-called notices, the work order was cancelled. And this has been, my lord, categorically mentioned in page 98, that chart, my lord, certificate of payment upon termination. And in the affidavit, my lord, we have already stated that whatever is due to the petitioner, that has been otherwise paid. Page 98. Package was AS 19102.
So you have paid how much? Mobilization advance of 27 and equipment advance of 55.
Yes, since there was no such mobilization at all.
In total, you
So it
have
was,
you paid him 83 lakhs. Out of only 40% work done.
my lord.
So therefore, the question as to whether the petitioner is entitled to the amount or not,
My
or
lord.
you are entitled to the amount or not, cannot be decided by this
Exactly.
court.
By this court, my lord. Not in the my lord petition. my lord.
Absolutely no. You challenge that I give all these matters are there, you go all before the civil court, fight it out.
My lord,
No more.
as your lordship pleases, but your lordship will just allow me to place some facts before your lordship.
What
my lord.
facts?
Some facts which are
What facts?
relevant for a my lord, adjudication of the present case, my lord. Just some, my lord. I'll just place one by one. It's the facts are longish. My lord, I think I should be able to convince your lordship, my lord. Just the facts. May I just put the facts chronologically, my lord. What had happened on 39/2008, my lord? I was allotted a contract, And the period of completion was for, my lord, initially for 11 years.
11 years.
Sorry, my lord, 18 months, 18 months, my lord. The period of completion was 18 months. Now, thereafter, my lord, various problems of one after another had come. These are all matters of record and these are not denied, my lord. In fact, my lord, if your lordship sees, I just point out,
Have you received 83 lakhs?
I have received nothing. In fact, the money for other works which I have completed, my
I'm
lord,
not on, I'm asking you, have you received 83 lakhs in respect to that contract?
83 lakhs, some amount they
Mr. Borua,
My
kindly
lord.
come to the point. Have you received 83 lakhs for the contract in question? We are only in respect to that question.
my instruction is nothing have been received, my lord. Nothing have been received.
You have not received any of these payments at page 98, which has been mentioned.
Page 98, it is their calculation.
You say that you have not received these amounts.
This till total recovery was, this is the mobilization advance.
So, as well
Yes.
as equipment advance, have you received or
Yes,
not?
yes, that they have given. They've given.
Out of that,
Yes.
they say that you have completed 40%.
Yes.
You say more.
No, I don't say that.
You also say
I
40%.
say 40%.
40%. Then it was terminated.
And it was terminated.
So what you said just before, only little bit is left,
No,
is wrong. Because more than half is left. If it is 40%,
in respect of this contract, my lord.
understood, this contract only we are concerned. And this is the contract which
Yes.
was terminated.
Yes.
There was no other contract which was
Yes.
completed.
Yes.
Now, if you don't go to the civil court, do you want this court to say that after 8 years or after from 2009 to 2013, when the contract was to be completed in 18 months, you having not been done so, then there was no just illegality on their part to terminate, then you take it out on that, or would you like to go to the civil court?
I'm not on that. I'm not on the undisputed question of facts, my lord. I'm only on the admitted facts. The factum that this.
Therefore, they are asking that 83 lakhs, which they have paid in the year 2000 up till 2012.
The 3 lakhs is, my lord, all right. But, my lord, what about the other contracts which I have successfully completed?
We are not here to adjudicate as to whether you have completed those works or not. How can you, within this case, be a case of complete the different types of aspects being brought in? Here is a case that this writ petition, the first writ petition pertains to the short tender notice, and the second is pertaining to the cancellation.
Cancellation.
These are two.
No. My lord.
Yes, these are the two. And an advertisement, short tender notice, a letter of acceptance being issued to somebody, as well as your cancellation. This is your first writ petition.
First writ petition.
The second writ petition is that pursuant thereto, the cancellation, you have filed an appeal. There's an appellate order passed in the year 2013. There's a standing committee order which has been passed in 2014. And in the year 2015, a communication which has been given to you on 14/8/2015. These are the three. And thereupon you are saying that all other dues in respect to other contracts should be paid to you. That's it.
Yes, because kindly see the completion certificates at page 155. Kindly, my lord.
How many contracts are there?
There are
apart from
multiple
that?
contracts. Page 155, my lord. Kindly.
How many other contracts are there?
1, 2, 3, 4, 5.
So all other 5 contracts have a different cause of action for your entitlement. This is no business out here.
Just try to clarify. These payments were withheld from me because of this order, my lord.
Obviously. So therefore, it is a separate cause of action which have no direction, nothing to do with these present cause of action. You see, what you are trying to do. First is in respect to one contract, you have challenged the letter of cancellation. One.
Termination.
Letter of cancellation, termination. Number 2, the consequential action of a short tender notice. Number 3, letter of acceptance issued to somebody. This is a contract of 2008. Now, the second writ petition says the first 3 pairs, ABC, is specifically in respect to the 2008 contract. The other portion of that, the D pair,
Mm.
is in respect to some other contract,
Mm.
which on account of the amount which have been withheld on this amount not been paid to you. Isn't that a separate cause of action?
Kindly see my prayers, my lord. I'll just point out. A, B, C, and D.
But I'm saying A, B, and C are in respect to the 2008 contract.
Contract.
D is in respect to remaining 5 contracts.
Exactly.
So
exactly.
that 5 contract is a separate cause of action which had nothing to do
It
with
is a-
these.
though-
Maybe the action, on account of the action, this must have happened
Exa-
out there.
Exactly.
But if they have not paid because certain amounts are due to them, it is for you to file a civil suit, get an order out there, not here, as to whether you have completed 40%. Could you have completed 40%? Why you could not do the 100% in 18 months? These are questions of facts which can be decided.
Exactly. That is exactly my point, my lord. My only contention is the manner in which the termination was done. Whether it is permissible by law as per the admitted facts, whether the contract provides for the termination by an executive engineer, that's number one, my lord. Number two, my lord,
Whether there was an extension granted.
my lord,
Whether an extension was granted to you. After 18 months, whether an extension was granted.
they had granted. In fact, their own letter will show. Can I just show?
No,
my lord?
whether an extension was granted beyond the 18 months.
They gave me a reply. They gave me a show cause. They delivered it on 3/12. Even before I could respond, my lord, they unilaterally terminated that.
I'm asking you whether there was an extension granted to you.
There was no letter of extension as
So
such.
therefore, it has done on an reflex of time. These money also should not have been paid to you after December 2009. This amount you have to return.
Because this jurisdiction point,
No, if the contract has
I-
not been extended.
my lord, will kindly see the contract for one moment, my lord.
No.
Kindly say page 151. Kindly see the contract, my lord. Because ultimately it is between contract between the state and the party. Kindly see page, it starts at 103. This is where the contract lies. Kindly see, my lord. 103 is where the contract starts and the relevant portion is 105. It defines the employer. Page 105, my lord. Has my lord got it, my lord? The employer is the party. The employer is the party as defined in the contract data who employs the contractor or carry out the works including routine maintenance. Now, your lordship will see
Read the next line.
the employer may delegate any or all the functions to a person or body nominated by him for specified functions. Now, that delegation will your lordship will find in the next page, page 106, clause 5, delegation. Kindly see, my lord. Clause 5.1, my lord. The engineer, with the approval of the employer, may delegate any of his duties and responsibilities to the other people after notifying the contractor. So they'll have to give me a notice, my lord, and may cancel any delegation after notifying the contractor. And now,
So
my
you
lord,
mean to say you did not know that the executive engineer was notified?
no, they did not notify. They have to, if they delegate, they'll have to give a communication. And no, it's not a question of fact, my lord.
Take your seat.
It's an
Let me
admitted
listen.
position.
No, now it is a case for dismissal. Not even giving you the time for going.
I have made a specific. My lord,
Heard Mr. A.K. Borua, the learned. Now you have shown me the way how to dismiss.
your lordship,
Heard Mr. A.K. Borua, the learned counsel, appearing on behalf of the petitioner. Mr. E. Gogoi appears on behalf of the respondent numbers. Appears on behalf of the PWD department. Both the petitions are taken up together for disposal by this common order. In WPC number 2515/2013, the petitioner is aggrieved by the actions on the part of the respondent authorities in issuance of a cancellation of the work order, in issuance of a letter of cancellation of the work order dated 3/12/2012, and the consequential actions by which the short tender notice was issued and a letter of acceptance having been issued to the private respondents. The petitioner has further sought for appropriate directions upon the respondents not to proceed further for withdrawing the performance security money of the petitioner from the bank of the petitioner. It is relevant to take note of that the petitioner was granted a contract for construction of rural roads, culverts, minor bridges, and routine maintenance of work for 5 years under the PMGSY regular page Roman 2007-8 by the communication dated 30/9/2008. Admittedly, the petitioner, in respect to the state contract, why you are saying it is 18 months, Mr. Why you are saying 18 months?
Well, page
27.
Huh?
20.
Wait.
No, it's not there in page 27. Well, in the page 65, Lordship will see
Page
65 of WPC, my lord, 5943. Period of completion 18 months. In the speaking order, it is mentioned. And it has not been disputed by the petitioner also.
But it was stated to be 5 years here. At page 27.
27.
Oh. Okay. For construction of road, rural roads,
No, there-
culverts,
yes, 1,
minor
2, 3,
bridges,
these are
and
various works.
minor bridges.
Yeah.
And further for routine maintenance of work for 5
5
years under the PMGCA web phase Roman 7, 2007-8. The period of completion of the work was 18 months. And thereupon, for routine maintenance for 5 years thereafter. Under such circumstances, the intended date of completion was on 15/4/2010. The petitioner was granted extension up to 30/9/2011. In the meantime, it is also relevant to take note of that the petitioner was paid the following amounts in respect to the said contract, the details of which are provided in a chart, page 98 of the second writ petition. Chart one, huh? As on the date of completion of the work, as on the date of, however, in spite of extension being granted, till the date of completion, till the date of termination, which was on 3/12/2012, the petitioner have only completed 40% of the work. and had received an amount of rupees 83,46,544. No, and again, it is relevant to take note of that এই চাৰ্টখনৰ আগতে লিখিব হা। It is relevant to take note of that in accordance with clause 45 of the GCC, the petitioner was paid an amount of rupees 46,55,970 and equipment advance amounting to rupees 80,24,170, totaling to rupees 1,26,79,960. Subsequent thereto, in terms with clause 45.3, advance payment was recovered by deducting from the bills of the petitioner the following amount, which is given in the chart herein under. It is the claim of the respondents that as on the date of termination of the contract on 3/12/2012, the petitioner could only complete 40% of the work. And from the deduction from the advance payments so made to the petitioner, an amount of rupees 83,46,544 would be realized by the department out of the advance so granted of rupees 1,26,79,960. The petitioner has challenged the termination on the ground that the respondent, where's the termination?
Termination is at page 48,
Of which writ petition?
5943 of 2016, the first one.
On the ground that the executive officer did not have the authority to terminate the said contract. And further, the reason on which the termination was carried out is incorrect in as much as it was beyond the control of the petitioner. That the petitioner could not complete the work within the time stipulated. it is relevant to take note of that the other consequential actions which have been taken by the respondent authorities is based upon the termination of the contract on 3/12/2012 by the executive engineer PWD. Therefore, it is depending on the decision in respect to the termination order dated 3/12/2012, the remaining relief so sought for by the petitioner can be taken into consideration. Insofar as the question as to whether the petitioner failed to perform as per clause 21 of the contract data of general conditions of contract is a question which would depend upon the petitioner proving that it was beyond the control of the petitioner, that the petitioner could not complete the work, for which the petitioner could not complete the work within the period as stipulated in the contract agreement, as well as the subsequent extensions. In the instant case, it would be seen, as already noted here above, the contract was for construction of various rural roads, culverts, and minor bridges, which were to be completed within 18 months. And as on the date on which the contract was terminated, the petitioner had completed only 40%. Question as to whether, therefore, it is the case of the petitioner that it was beyond the control of the petitioner, for which the contract could not be completed within time, is dependent upon the petitioner proving the same, which would in result require adjudication of evidence, which this court, in exercise of the powers under Article 2 to 6 of the Constitution, cannot do so. Let this court now take into consideration the second aspect on which the learned counsel appearing on behalf of the petitioner, Mr. A.K. Borua, harps on. That is, that the executive engineer, PWD Nagaon, did not have the authority to terminate the contract. In that regard, the learned counsel, referring to the contract agreement submitted, that the general conditions of the contract specifically define the employer to mean a party as defined in the contract data who employs the contractor to carry out the works, including routine maintenance. This court also finds it relevant to observe that a definition of the said employer would also show that the employer may delegate any or all functions to a person or a body nominated by him for specified purpose. Clause 5 of the general conditions of the contract, more particularly clause 5.1, stipulates that the engineer, with the approval of the employer, may delegate any of his duties and responsibilities Mr. Ikeburu, the learned counsel has submitted that the delegation has to be made in terms with clause 5. And in that regard have referred to clause 5.1, which being relevant is reproduced here in under is 106. From a perusal of the above quoted clause, it would show that it is the engineer who has to take approval with the who has to with the approval of the employer may delegate any of his duties and responsibilities to the people after notifying the contractor, and may cancel any delegation after notifying the contractor. The engineer, the term engineer have also been defined in the general conditions of contract to mean a person named in the contract data, bracket, or any other competent person appointed by the employer and notified by the contractor, comma, to act in replacement of the engineer, bracket 2, who is responsible for supervising the execution of the work and administering the contract. Clause 52 stipulates, it deals with the aspect pertaining to termination. In terms with clause 52.1, the employer may terminate the contract if the contractor causes a fundamental breach of the contract. The learned counsel, in the backdrop of the above, the learned counsel appearing on behalf of the petitioner has submitted that the petitioner have not been notified that the executive engineer have been delegated the power to terminate the contract. And it is on the basis thereof, the learned counsel appearing on behalf of the petitioner submits that the executive engineer did not have the authority to terminate the contract. In the opinion of this court, the said submission is completely misconceived, inasmuch as the termination can be done by the employer, and the employer has the authority to terminate, has the authority to delegate its functions to any person as would be available from the very definition of the employer. Clause 5.1 is in respect to a delegation made by the engineer to some other authority, which have no relevance in respect to the termination of the contract. Under such circumstances, the second ground on which the petitioner have assailed the termination letter of termination of the contract is, in the opinion of this court, is misconceived. At the cost of repetition, this court duly observes that as regards the first ground, comma, that the same cannot be adjudicated by this court and can only be adjudicated by an appropriate forum wherein evidence can be led. In the backdrop of the above, let this court consider, no, take your seat. Whatever mistake I've done, you take it before the
Only
revision.
one ground was, additional ground was there at page 48, paragraph 48, this
What is
ground
that?
of bias. That chief engineer who had dismissed my appeal under 24.1, he sat in his own appeal before the standard empowered committee. He could not have done that.
We are not concerned. When I'm upholding this order,
Yes.
remaining orders become
I'm
inconsequential.
just pointing out the grounds.
If the trial court have passed an order, High Court has the High Court, the district judge has passed an order, and then the order has been now the High Court says that okay, the trial court's order is bad, good. Then the remaining order remains inconsequential.
So I'm just pointing out the grounds. And that page,
Take your seat.
Aman.
In view of the above, comma, it is therefore the opinion of this court that this court does not find any good ground for interfering with the letter of cancellation of letter of termination of the contract dated 3/12/2012 in the present writ proceedings. The consequential actions for issuance of a short tender notice and letter of acceptance being issued to the private respondents cannot be faulted in view of the fact that this court does not find that the letter of termination to be contrary to the provisions of law. In the backdrop of the above, let this court now consider the reliefs which have been sought for in the second writ petition, being WPC number 5943/2016. Petitioner have sought for setting aside the orders dated 27/2/2013 passed by the Chief Engineer Public Works Department on appeal. The order dated 26/8/2014 passed by the Standing Empowered Committee, whereby the letter of termination which have been issued in favor of against the petitioner have been upheld. Taking into account that this court in the previous segments of the instant order have categorically held that the order dated, the letter of termination does not call for an interference under Article 2 to 6 of the Constitution. For the reasons, So, the question of going into the legality or validity of the subsequent orders affirming the order of termination be a useless, it would be a futility, would be a futile exercise. This court now finds it relevant to take note of the relief sought for as regards the communication issued by the executive engineer to the petitioner dated 14/8/2015, whereby the computation certificate of payment upon termination of the contract was forwarded to the petitioner, which is dated 28/1/2013. From a perusal of the said document, it is seen that on the basis of the advance so paid to the petitioner in respect to the mobilization amount so paid, mobilization and equipment advance so paid to the petitioner to the tune of rupees 1,26,79,960, and the amount which have been recovered from the petitioner by deducting it from the advance bill an amount of rupees 43,33,416 remained outstanding to be recovered. It is also seen that from the said amount, an amount of rupees 43,33,416, an amount of rupees 28,49,644 was recovered and adjusted from the performance security, and rupees 13,86,582 was recovered from the incomplete final bill, so and so. And therefore, only an amount of rupees 97,190 remained to be recovered out of the advance provided to the petitioner. It is also seen that an amount of, in addition to that, an amount of 20% of the value of the contract, in addition to that, an amount of rupees 1,10,18,940, which is 20% of the value of the work not completed, representing the employee's additional cost for completing the balance work, have been imposed upon the petitioner. The question as to whether such an imposition is permissible under law as per the contractual terms and conditions is a question of fact. Inasmuch as the certificate do not mention as to how the said amount have been arrived at. In the backdrop of the above, if this court now takes the relief which have been sought for, in the remaining reliefs which have been sought for in WPC number 5943/2016, it is seen that the petitioner have been, that on account of the claim of the PWD of an amount of rupees 1,10,18,940, along with rupees 97,190, various bills of the petitioners have not been disbursed, have not been paid. You are adjusting that amount.
Yes, sir.
From that amount.
Yes.
Mr. B. Gugoi, the learned counsel appearing on behalf of the PWD department, submits that the said amount from the various other, in respect to other contracts, any amount which is being payable is being adjusted against the claim of against the entitlement of the PWD of the amount of rupees 1,10,18,940, along with rupees 97,190. Mr. Gugoi, kindly show me the clause by which you can adjust it from other bills.
Lordship. It's 53, madam.
Huh?
53,
Page 116,
53, yeah.
page 116.
53, madam, 53.1. The
And then
contract is terminated because of
fundamental
financial
and-
clause, the engineer shall issue a certificate. If any less advance payment.
53.1. 53.1.
They have relied on 53.1, page 99. Kindly see, my lord, the second paragraph. It says, second paragraph, my lord, I'm just pointing out, still there, rupees so and so left unrecovered from 11,000, which is debt payable. Further, as per clause 53.1 and contract data, say 11,000 has to pay back the employer an amount of so and so. That is 20% of the value of the work not
Understood. They are doing it on the basis that, nah.
So 53.1 does not stipulate that 20%, it doesn't say. Kindly see page
It's
116.
okay, it is illegal. I understand that it is illegal, but
And
they can recover from other payment. Kindly come to 116.
116.
If any amount is still left unrecovered, it will be a debt payable to the employer.
Exactly. But
Meaning thereby they will be recovering it from somebody else.
that amount, that 1 crore 10 lakhs 18,940, that 20%, how they arrived at 20%, my lord, they say additional cost of the employer. Now, in this case, even the tender was not floated for the subsequent work. So therefore, there's no additional cost.
I have understood that. Have I not mentioned about that in that order to that effect? They have not mentioned, given details
Yes.
how it is.
In the affidavit, no justification.
The said exercise of power has been carried out in terms with clause 53.1 of the general conditions of the contract. It is the opinion of this court that the said amount, the opinion of this court, that the legality and validity of the imposition of the amount of rupees 1 crore 10 lakhs 18,940, which as per the respondents is 20% of the value of the work not completed, is required to be questioned in an appropriate forum wherein evidence can be led. Inasmuch as unless the said amount has been predetermined as the damages in terms with section 73 of the Indian Contract Act 1872, the self-imposition, the self-claim of the said amount the claim of the said amount, and thereby deducting from the other bills of the petitioner would not be permissible. This aspect again would require an elaborate adjudication on the basis of evidence. Consequently, the writ petition stands disposed of with the following objections and observations and directions. This court does not find good ground to interfere with the impugned notice of impugned letter of termination, cancellation of the contract dated 3/12/2012 on the ground that it has been issued by the executive engineer. Number two, the ground on which the letter of termination has been issued, that is the petitioner's failure to act in terms with clause 21 of the GCC, the question of fact which can only be adjudicated in a forum wherein evidence can be led. shall be the burden of the petitioner to prove that it was beyond the petitioner's, it was the petitioner, for circumstances beyond its control, could not complete the work within the time stipulated. Number 3. The petitioner is granted the liberty to assail to challenge the legality and validity of the imposition of rupees 1,10,18,940, which is being sought to be recovered from the bills of the petitioner, other bills of the petitioner in respect to other contracts. The said exercise, the said legality and validity has also to be carried out, has also to be challenged before a forum wherein evidence can be led. Inasmuch as shall be the burden of the respondents to show, the PWD to show that the said amount constitutes 20% of the value of the work not completed. First. In that view, this court have also taken note of that the petitioners have been pursuing the present writ petition, both the writ petitions, bona fidely and diligently, with an assumption that this court would entertain the instant writ petition. However, this court, as above mentioned, is not in a position to adjudicate various factual disputes. Accordingly, it is therefore the opinion of this court that if the petitioners herein approaches the competent court of civil jurisdiction or any other appropriate forum, challenging the letter of termination to the extent indicated herein above, as well as claiming the other dues and challenging the imposition, the period from 6/5/2013 till date be excluded while computing the period of limitation.
My lord, the bank has sought another opportunity, my lord, to file the affidavit.
How much time?
2 weeks may be given, my lord.
Only 2 weeks. I gave a final opportunity.
My lord.
My lord, I have a small submission, my lord. In regard to item number 26, I may be allowed to withdraw this petition, your lordship, as instructed by our petitioner, your lord. Send a letter through WhatsApp to withdraw this petition, your lordship.
Paul Kakoti,
Yes, lordship.
what is your name?
S.A. Borboya, lordships. S.A. Borboya.
You are there?
Yes, Lord.
Kind of Wakalakana?
Yes, lordships. My name is reflected in the cause list also. S.A. Borboya.
A. Bhuya, the learned counsel appearing on behalf of the petitioner in WPC number 1179/2020 submits that he has instructions to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. However, taking into account that the materials on record in of WPC number 117/2020 would have relevance while indicating WPC number 3110/2026. The records of WPC 1179/2020 be tagged along with WPC number 3110/2026. Mr. Aibo Thakur appearing on behalf of the petitioner, on behalf of the Assam Cooperative Apex Bank, submits that week's time is required for filing the affidavit as directed by this court by the order dated 24/7/2026. Accordingly, list this matter on 30/9/2026. The affidavit on behalf of the respondent Assam Cooperative Apex Bank be filed on or before 25th of September 2026.
I am paying for respondent 3 in this case.
Which case?
Item 27. Item 27.
1179.
No, 311.
RBI.
Public.
Lovely.
Please, Your Lordship, in the morning, I've tried to mention.
Otherwise, my lord, instruction has been received, my lord. Otherwise, I have received the instruction.
Is in Gauhati.
Gwalpara.
Gwalpara.
Gwalpara. Gwalpara.
Valijana Revenue, sir.
Do one thing. File an affidavit. Because this affidavit will be required. Then we have to make those people party. See, for the purpose of removing the flood,
Yes.
or what is artificial floods, there is a requirement of straightening the canal.
Canal, my.
Canal is straightened, there will be a requirement of demolishing somebody's buildings. The boundary works.
Yes. 5-6 families.
Now, at the behest of the petitioner, if we do so, the others will be affected.
Yes.
We bring on record this
Yes.
instruction by affidavit. Mr. N. Das, appearing on behalf of the Circle Officer, Balijana Revenue Circle, has produced an instruction dated 9/1/2026 issued by the Additional District Commissioner, Gwalpara, The same is kept on record and marked with the letter. Taking into account the contents of the said instructions, it is the opinion of this court that the circle officer, Balijana Revenue Circle, should bring on record the said instruction by filing an affidavit so that appropriate directions can be passed. This matter again on 25th September.
My lord, it will be done.
The affidavit in the meantime be filed by 22nd.
Record is conducts. Record conducts.
What is the matter about?
Land of the petitioner has been taken under Assam Mala without there being any agreement, without there being any compensation.
Where is who is appearing for that? Government?
Dinat Lordship is
Dinat
coming.
Mal-
He is in court, one Lordship is coming on the way, Lordship.
An additional affidavit was filed by the DC. My lord.
Respondent number 2.
My lord.
Does he say?
Agreements pertaining to 2 plots of land were been annexed without there being any compensation, without there being any date, my lord, at page 150.
Award is there.
My lord,
Award has been enclosed.
that, my lord, a document has been enclosed, page 170, my lord. This is pertaining to only one village, my lord. Land of the petitioner consists of 3 villages, my lord.
Huh?
$170, my lord, it pertains to 1 number Bardwar, my lord, village. 2 number Bardwar and 3 number Bardwar Bagan, my lord, nothing, no award, nothing, my lord.
Number 1 Bardwar.
Yes.
So Bardwar Tea Company has been given how much? Dag number 16. Per bigha. Hotel Iman. And again, is being given number list 1 Bardwar Bagan village. So there are various amounts.
Yes, my lord.
Have you got that money?
No, my lord.
Why? The land has been taken.
Yes, my lord. Construction has been completed, my lord.
Then why no payment has been made?
Page 115, my lord, their statement is that I did not cooperate, my lord.
It's okay. You take the money. How much is the amount?
No mention, nothing, my lord.
Huh?
There is no mention.
So there is an award pass now, which is enclosed in Annex 4 or 9.
That is, my lord, in connection with 1 number Bardwar, my lord. There is another 2, my lord, 2 number and 3 number, there is nothing. If my lord comes to page 154, my lord, 154.
Yes.
This is one of the agreement, my lord, although there is no date, no compensation amount, but this pertains to 1 number Bardwar at the table, my lord.
All are FS, pattern number 1. On the Bardwar.
Then, my lord, page 161, my lord. This pertain to 3 number Bardwar, my lord.
Yes, tell me, this is only in respect to 1 award has been passed.
Well, we have given one in the, I have the record, in the record, well, I have find, it, this is in respect of village number 1, border village number 1, and
We are concerned with patta number 3.
3. Well, in fact, border village number 1, border village number 2, and border village number 3. Altogether in that particular process, 13 villages were covered. Petitioner is concerned with 3. 13 villages were covered in that particular acquisition process of the process.
And then
The petitioner is in respect of 3. If Lordship kindly takes up page 133, my lord. That is the 132.
Yes.
This is the notice, my lord, issued, published in the newspaper.
Hmm.
These are the 13 villages, and land has been mentioned. Total land is 87 bigha, 3 katha, 17.5 lacha.
We are concerned out here to around 54, 55
Yes,
bighas.
1, 1, 2, 3. Serial number 1.
55 bighas,
Lot,
56
lot,
bighas.
lot.
Yes. Then you have the award for all the 55 bighas.
But in the record, my lord, I have.
No,
come
no,
across
you have filed an affidavit.
Lot.
There is one award which has been passed in respect to which is annexure 9.
My lord,
These are regarding,
village 1, border village 1. At page.
these are all village 1, patta 1,
170, page 170.
40 years sooner.
Lot.
But this is grant 1, patta 1, again this is different area. These are patta 1, 30 sona 2. Now this is patta 2. Patta 2 is for which village? This is also Badwar.
My lord,
Page
the
185.
entire thing is only with respect to village number 1, my lord.
No. Page 185 kindly come. This is patta 2.
But this is for under village border number 1. That
Badwar village has how many pattas?
border kindly, my lord,
Badwar village, the pattas are 30 sona 1, patta 1. Then FS grant 1. Just and you have again, this is patta 1, patta 3. So where are the awards for the others?
here we have not annexed, but copies are here, my lord.
Again, you said that you are going to file it.
Well, in fact, record.
It was too many.
record
We are only concerned with their pattas.
their pattern. Well, in fact, the
File another additional affidavit bringing on record the other awards.
estimates of all 13 villages we have annexed. That is at page 135. All 13 estimates are there.
Yes. No, it's okay. This is for one Badwar.
Border 1,
It's
then
5 crores 337,000.
border 2, border 3, Lordship will find.
Now that is okay.
Lordship.
But the petitioner have not received any amount.
But in fact, what in the affidavit we have said, Lord, the process for releasing the payment to the petitioner was on. And they have already submitted whatever required affidavit, form B, form C, they have submitted. Well, in respect of village 1 and village 3, in the record I have seen. In respect of village number 2, it is not, I have not seen in the record. 1 and 3, we have annexed. In fact, the bank details also they have submitted. And
Then why are you not making the payment?
all other the landowners they have received, but in respect of border, they did not come forward at that last stage.
What? They are fighting a litigation before this court and they are not coming forward. Don't make that statement.
That is what-
Okay, if you
but, yeah,
record
fine.
that statement out there, we record it and let the petitioner go and take.
Yes, sir.
And
They
give
can
an
approach,
update.
they can approach and go.
We go next week. We have it next to next week.
Yes,
Get the money. We
yes.
have already provided the details as a bank account.
Yes.
Provide the detail. So all these 3 villages, Badwar villages, you have already started disbursing.
But
Have awards been passed in respect to 3?
already
No, Mr. Nath, kindly come directly to the point.
No.
Have you passed awards in respect to the 3?
But
If you have passed the amounts which are there, next time you bring on record the other two awards.
not
Only one award appears for Bordua Village one.
two I have not received.
Because if you have the awards, they can very well, you are doing it under the Assam Requisition and Acquisition Act.
No, but it is under Assam Mala direct purchase.
But there is no agreement.
No. No. In fact,
No, whatever may be,
it is
if
under,
they don't agree to be an agreement, it will be taken as an acquisition under the Assam Requisition and Acquisition Act.
no, Mala, that is what we have shown. Kindly see
Where
page,
is the agreement?
page 148. Page 148 is they have given us under Assam Mala only, Mala. Page 148, this is the affidavit they have submitted to us.
Who is this?
The Borduar, Mala, the representative of Borduar, he is the director.
No, I'm asking about, we are concerned with Bordua Tea Company.
Yes, Mala. This is in respect
Tea
of one
and
number.
Timber Company. Where is Bordua Tea and Timber Company's agreement, affidavit?
That I have not seen, but
Then you see, we maintained it as an award. Allow them to challenge it. That's the only way out.
Mala, this is if Lordship kindly Mala, takes up 148,
I've seen it.
that is what Mala, in respect of Borduar 1, they have submitted this document that they have no objection, they are ready to accept the amount. The minutes of the district
All
committee.
I understand, Mr. Nath, kindly appreciate one thing. This is not being signed by the Bordua Tea Company.
Director has signed.
Where?
Kindly see the seal is there, Mala, seal and signature is there. At page 148, at the vertically, Mala, they have signed. I have the original copy, Mala.
So this is signed by Lalit Kumar here.
Yes,
Okay.
Mala. He's the director of the company.
We the absolute owners of the following dark numbers so and so. And we are the sellers of Iman proposed government Mala scheme and so. Agreed for sale of pensioning and so. Okay, so we have agreed. Now what is the value?
Page 154, Mala. The agreement. Value is as per the minutes of the DLC, district level committee, that Lordship will find at page 120. 120 it starts. In respect of all 13 villages, the value has been fixed. 120, Mala. Annexure 4.
Okay.
In respect of Borduar, kindly come to page 124.
Bordua.
Borduar 1.
Industry this much so and so. This is how it has been agreed to.
Yes, Mala. This is known to them.
And this was done when?
This was done, Mala. Date is there, Mala.
Minutes of the meeting held on 28/9. And when was the affidavit filed?
Thereafter, Mala.
22. So therefore, they had the notice about this.
They have the knowledge in respect of
So
village.
they say that they are okay. It's okay. Now
Not
you do one thing. We need to, whatever may be, we need to regularize this.
Not so much.
But next time onwards, ask your people to have an agreement.
True.
Not this.
Well, I have given all the awards. Lordship may see all the landowners have signed and taken the money.
Understood. But my question is, where is the award for the other two?
But in respect of 1 and 3 in the record, I have seen 2, Mala, they are in the process of tracing out. I have not got it. Yeah.
Look, if we do one thing.
Mala.
We have it after 2 weeks.
Mala.
In the meantime, let the petitioner visit whom? Whom should he do?
DC, Mala?
The DC.
Yes.
Let him visit the DC.
Lordship.
or some authorized
For the
person?
concern ADC is there, my lord, they will go.
This is with the concerned ADC
Yes, yes,
on a particular date, and thereupon receive it, the amount.
yes, my lord. The amount is there.
Heard Mr. H.K. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the respondent number 2. Pursuant to the orders passed by this court, more particularly dated 27/7/2026 and 31/7/2026, an additional affidavit has been filed by the respondent number 2 on 18/8/2026. From a perusal of the said additional affidavit, it is seen that on 28/9/2021, the zonal value of the various border villages, the zonal value of village number 1, 2, and 3 of Bordwar Bagan have been duly determined. It is further seen that in pursuance thereto, on behalf of the petitioners, affidavits have been filed stating that they have no intention. They're stating that they have no objection in the acquisition of the said land, subject to the payment of the compensation which stood already determined on 28/9/2021. It is, however, the case of the petitioner that till date the petitioner have not received the compensation. This court have also taken note of that in only one of the Burdwar villages, the award statement have been enclosed as Annexure 9. However, the award statement in respect to Burdwar village number 2 and Burdwar village number 3, insofar the same has any relation with the petitioner, have not been enclosed. Deena, the learned counsel appearing on behalf of the respondent number 2, submits that affidavit, another additional affidavit would be filed, bringing on record the award statement insofar as the Burdwar village number 2 and 3, village number 3, insofar the said award statement has relevance in the case of the petitioner. But there might be others also, so I reduced it.
Not- And my lord, the agreement we have annexed, the agreement with the PWD and the petitioner, it is page 154.
List this, sir. The learned Mr. Deena further submitted that that on account of certain indifference, the payment of the compensation has not yet been disbursed to the petitioner. And if the petitioner visits the office of the ADC, Kamrup Rural, the same, the payment of the petitioner, payment entitled to the petitioner would be disbursed. Considering the above, list this matter again on 11th of September 2026. In the meantime, representative of the petitioner, may approach would be at liberty to approach the concerned additional district commissioner, land acquisition, upon such approach, the respondent authority shall disburse the amount as per the entitlement of the petitioner. An update be given on the next date. You go there.
Much. Well, I'll take back the original.
Yeah, taking right. You file that. We keep it on record so that later.
Lordship.
Wait, please, Your Lordship. In this case, Lordship, I am challenging the order passed by the Revenue Board in the review application as well as in the revenue appeal matter, Lordship. Our case is that, Lordship, we applied for recording our name in our predecessor's land, Lordship. That was granted by the learned ADC, which was challenged by the private respondent before the Revenue Board, Lordship. And during pendency of the revenue appeal, Lordship, our predecessor died. So we have filed an application for implement that was objected by the appellant, and thereafter that was rejected, Lordship.
So
my,
this judgment is passed against a dead person.
yes, Lordship. So my humble submission is that the judgment passed in revenue appeal is non-est in the eye of law. Thereafter, we filed a review application, Lordship. In the meantime, the private respondent died. So again, Lordship, we filed condonation application and substitution application. Those were rejected and accordingly.
Who is the appellant?
Lordship,
Who is the appellant in the revenue appeal?
review is the petitioner number 1, Lordship.
Number 1.
Yes, Lordship.
The decision was initially passed against some dead person
Yes, Lordship.
by the revenue board.
Yes, Lordship. In that case also, petitioner number 1 filed an application for implement, but that was objected, Lordship. Page 63, annexure 9, Lordship. My humble submission that, Lordship, the judgment.
The initial order was passed by whom?
ADC, Lordship.
ADC, in that order, they have categorically mentioned that this person had died.
Yes, Lordship.
Is that?
Page 46, annexure 8, Lordship.
There is somewhere mentioned.
Page 48, Lordship, second paragraph. In relation to this case, one Musammat Ranima Begum, wife of late Nurul Islam, submitted in writing that late Abrar said. So, Lordship, it was contested by the legal heir. End of the paragraph, Lordship. In the meantime, Muhammad Nurul Islam passed away.
Okay, so this appeal was filed against the dead person.
Yes, Lordship.
So the judgment which was pronounced on 31/12/2020 is non-est.
Yes, Lordship. Our submission, Lordship, that
Yes.
is done.
The Chaudhary.
My lord, the claim was filed by my lord, the present petitioner's predecessor, so-called predecessor, Nurul Islam. He filed an application before the circle officer. And my lord, his case was Nurul Islam.
Nurul Haq is another person, Lordship. His claim was already negated by ADC, Lordship. You have no right, so his claim was negated, Lordship.
But the order was passed in whose favor?
In both the cases, Lordship. A common order was passed.
In this case, which was passed, it was passed in favor of, that the order passed by the ADC was in favor of whom?
Nurul Islam, Lordship.
Oh no, the order was passed in favor of Nurul Haq.
No,
Nurul
Lordship,
Islam.
both the persons are there, Lordship. Both the case numbers are there.
No, kindly see page 53. Claims that so-and-so was mutated in so-and-so, the actual so-and-so by virtue of Iman. It was granted, but in the draft Jamabandi is so-and-so.
It only says original pattadars be restored accordingly.
So the name of but application was not filed by Nurul Haq.
No, Lordship. Nurul Haq was made party in the revenue appeal, but he did not contest it.
No. I'm concerned with the ADC's order.
ADC order in respect to the Nurul Islam's application, Lordship. In his
So
favor.
you were not a party there.
No,
Your predecessor was not a party there.
Nurul Islam was a party, my predecessor.
Your predecessor is Nurul Islam or Nurul Haq?
Nurul Islam, Lordship.
Nurul Islam. He
Yes.
filed the application.
Yes, Lordship. And he died, then Ranima came, Lordship.
Ranima came. And Ranima is who?
Ranima is wife
of
Nurul
Nurul Islam.
Yes, Lordship.
And in that case, it was held that Nurul Islam expired.
Yes, Lordship.
So in the revenue appeal which was filed, they filed it against Nurul Haq and Nurul Islam.
Both were there.
Whereas, and in that case, Nurul Haq, Nurul Islam was already dead.
Nurul Haq is respondent number 1. Nurul
He did not
Islam,
participate.
Lordship.
But Nurul Islam,
He died
obviously, so yeah. Then you filed an application for
for implement.
that was rejected.
Yes.
Then you filed a review.
Yes, Lordship.
Review was also rejected. So you are here.
During review, Lordship, private respondent died. Kamala Devi died. So we filed application substitution and condonation. This was rejected. No abatement petition was filed. It already abated. So on that
But
ground,
that has become inconsequential,
Lordship.
taking into account that judgment was passed against the dead person.
yes, Lordship, that judgment is non-est in the eye of law. So Lordship, the question of review will not come.
My lord, the circle officer by an order on 7/1/2014, my lord, the application was, my lord, forwarded to the ADC for decision. That was in 2014. His claim was that on the basis of an of a RTI reply for a particular period, the asking for certified copy of the sale deed of the predecessor of the petition, my lord, the respondents herein. That RTI says that there is no sale deed for that period. My lord, my sale deed was of, my lord, 2000,
Maybe the
19
order was passed.
my lord.
That's only one has to understand that an order was passed by the by striking out your name in an application filed by Nurul Islam.
Yes.
That order you have challenged, whereby you have made Nurul Islam a party, whereas Nurul Islam was dead.
My lord.
So the appellate judgment which was passed by the Assam Board of Revenue has to be regarded as a order passed against the dead person.
Now, my lord, the question here is, my lord, when the matter was pending before the ADC, ADC passed the order on, my lord, 18/12/2018. And Nurul Islam died on 19/10/2016. And my lord, Islam was the petitioner in that case. And then, my lord, ideally, an application for substitution ought to have been filed. That was,
Okay, but whatever may be, that application was allowed where the person was duly represented and this has been duly taken.
he
note
was
of in
not,
the
my
order.
lord, my submission before your lordship is that he was not duly represented.
This page 48 is the test.
My lord, your lordship will kindly see, that is where the, my lord, the issue lies. The only one sentence is there saying that Ranima Begum is representing. There has not been any manual application for substitution, and this
Is
statement,
there
my
an
lord,
application for substitution required in the ADC?
my lord, it
It
has to be.
required.
No, my lord, for representing, my lord, one has to file an application, and we have the, my lord, the right to file an objection. It was not never
No, this
adjudicated.
application was filed and in this case, one so and so submitted a letter dated so and this was subsequently Ramzan Ali and all these things. In the meantime, expired is now representing the case. See, in the meantime, Nurul Islam passed away and so is now representing the case. So therefore, as per the ADC, there is no required. And there is for the DC in that regard, there is no. However, in the Assam Board of Revenue, when an appeal was filed, even in a case of an abatement, there is a requirement of filing an application, which is not there before the DC.
No, my lord, my submission before your lordship is that, my lord, whether, my lord, Ranima Begum is the, my lord, has been substituted or not, there has to be an order. There is no order, my lord.
Not necessary. Before the ADC, not necessary, because here the ADC categorically says that so and so is representing her case.
My lord, representing someone is, that is not an adjudication of the, my lord, substitution of any, my lord, legal
It is an
heir.
order passed by a revenue authority, so obviously you cannot look into it in the.
My lord, in fact,
the judicial
my
order.
lord, when we obtain the certified copy, there is no change, my lord. Ranima Begum's name does not figure in the, my
But
lord, order.
when you obtained the certified copy, you did not read that page 48.
No, my lord, the question is when, my lord, it's a question, my lord, whether the,
I think the division bench will help you out. Let me allow the petition.
my lord, my
Not
submissions
satisfied.
may kindly be considered, my lord.
No, I'm not.
No, firstly, my lord, my
Mhm.
submission is that this is a procedural.
No, this is
My
not a
lord-
procedure. You are filing an appeal against a dead person. Sorry.
Same ground was taken in the maintainability issue in the objection itself, that my petition was pending before ADC. We have not, Lordship, the ADC before we have not substituted. So that proceeding is on a dead person and it is non-est in the eye of law, Lordship. That was taken a ground in the objection itself, Lordship. So the same objection they have taken in the Lordship proceeding of ADC. So it is an admitted position that, Lordship, if a order passed on a dead person.
Now,
that is
Assam
non-est.
Board of Revenue Regulation 19 procedure in case of death of so and so. If an appellant or an appellant dies while the appeal or AI is pending and cannot be proceeded unless the legal representative, the board shall adjourn the further to enable the legal, if the legal fails to do so within a year. When the respondent dies, so there we are having a similar provision as per the Assam Board of Revenue Regulation in a proceeding which is similar to Order 22, Rule 3 and Order 22, Rule 4. However, in the case of an ADC, there is no requirement for such.
My lord, that application was filed and my lord, that has been rejected.
Who?
That application for substitution was filed by them, my lord, that has been
Who has
rejected by the
rejected?
Assam Board of Revenue.
So therefore,
That is in review, Lordship.
that's in a review. Forget about review. Review has also, this is a non-est order.
My lord,
So therefore, I gave you an opportunity. Now you want to contest it. The
My lord.
only thing I can do to you
No, my lord.
is you go there. I set aside both these things, directing the Board of Revenue to take on account that application and substitute them or implead them, not substitute, implead them and proceed afresh. That is what I wanted to do. But if you want to contest it, take this judgment.
no, my lord, if that, if your lordship says that the matter should go back to Revenue Board, and my lord, the Rani Babagam has to be substituted, my lord, I have no objection to
Not
that.
substituted, impleaded.
Impleaded, my lord.
That
I know,
application be taken as an impleadment application for them and that be impleaded. But this order has to go. The judgment, both the judgments have to go.
That will not prejudice me, my lord.
That is what I wanted to pass that order on the last occasion. But you said no, I have something else to submit. So therefore, take my decision on the point that it is a non-est order. So therefore, whatever it is, you have not challenged that order.
And
You
Lordship,
have to now go to the division bench.
Lordship, in page 121 already this,
there.
Lordship, in page 121 paragraph 8, it was
Madam, I
already
am in
admitted,
your favor.
Lordship. Already admitted that it is non-est in the eye of law, Lordship.
Who?
Lordship, my respondent. In the preliminary objection, they have stated that the ADC's proceeding is non-est in the eye of law, Lordship. So
Right.
on the same ground, Lordship, that it is passed on a dead person. So, Lordship, it is admitted position.
No,
that-
there is no requirement in before the ADC.
Lordship,
That is a fundamental this difference. In an ADC proceedings, there is no question. But however, when it comes to the Board of Revenue,
Lordship, it is
the
required.
proceedings has to be against the first has to be filed against the live person,
Lordship.
living person. Secondly, if there is a death, similar provisions are there pertaining to
19 and 20, Lordship.
19 and 20,
Yes.
which is parameter to Order 22, Rule 3 and 4.
Yes.
So, but I think this is not a case of substitution. I think we have to go as per the
Amendment of,
scope of section 149 of the CPC, whereby the legal representatives can be brought in. So therefore, instead of filing an application, your application be taken on record and then impleaded. I think that is the best way. And the appeal be then decided. That is what I wanted to pass on the last one. Heard Ms. R. Chaudhary, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioners. Mr. Who appears for whom? So-and-so for 1, so-and-so appears for respondent number 2 to 5. Miss the M.K. Chaudhary, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent numbers 6 to 8. The present writ petition has been filed by the petitioners, assailing the order dated 31/12/2020, passed by the learned Assam Board of Revenue. In case number in case number RA number 09 bracket K oblique 2019, and the subsequent rejection of the review application filed by the order dated 26/6/2025, which was registered and numbered as case number 23 RA bracket K bracket RVW bracket close oblique 2021. The petitioners herein claim that they are the owners of a plot of land at measuring 2 bighas, 3 lechas, on the basis of their inheritance. The said plot of land was owned originally by one Hafizan Nessa, the owner of a plot of land measuring 2 bighas, 3 lechas, covered by DAG number 916 old oblique 402 new, under village 2, Zaporigo Gaon, lot number 4, under Beltola Moja, under Dispur Revenue Circle in the district of Kamrup Metro, Assam, for the sake of convenience referred to as the land in question. It is the case of the petitioner that the said land was originally owned by one Hafizan Nessa, the predecessors of the petitioner, that is Muhammad Nurul Islam, of the petitioner, that is Nurul Islam, bracket since deceased, was the grandson of late Hafizan Nessa, and applied for correction of the revenue records before the learned circle officer, Dispur Revenue Circle, and delete the name of one Kamala Devi Saraugi, the predecessor in interest of the respondent numbers 6 to 8 in the present proceedings. The said application was registered and numbered as Miss Case number 655 oblique 2014. On 7/1/2014, the circle officer passed an order and forwarded the same to the deputy commissioner for due information and to do the necessary action to record the name of the legal heirs of the original patadas in the revenue records. However, one Nurul Haq, claiming himself to be the legal heir of late Hafizan Nessa, filed an application before the Deputy Commissioner Kamrup Metro for recording his name in place of late Hafizun Nessa, which was registered and numbered as Miss Case number 41/2016. The Deputy Commissioner, upon receipt of the order dated 7/1/14, passed by the Circle Officer, Dispur Revenue Circle, took into consideration both the Miss Case number 41/2016 and Miss Case number 66/2014 and passed an order on 18/12/2018, thereby striking out the name of late Kamala Devi Saraugi. It is relevant to take note of that during the pendency of the two applications, during the pendency of the proceedings before the learned Additional Deputy Commissioner Kamrup Metro, in connection with KRC M 41/2016 and KRC M 66/2014, the later of which was filed by late Nurul Islam. It was duly informed to the learned ADC, that Nurul Islam had expired and he was being represented by his wife, that is the petitioner number 1 herein. Petitioner number 1, na? First. Be that as it may, the respondent late Kamala Devi Saraugi being aggrieved by the order dated 18/12/2018, filed an appeal before the learned Assam Board of Revenue, which was registered and numbered as RA 09/K/2019. It is, however, it is, however, pertinent to observe that in the said appeal, the applicants of ARC M 41/2016, that is Nurul Islam, and KRC M 66/2014, that is Nurul Haq.
Alia
Nurul Haq,
Alia
প্রথমত Nurul Haq, তাৰপিছত were arrayed as the sole respondents. This was done so without taking into consideration that Nurul Islam had expired during the pendency of the proceedings before the ADC, and the same was duly reflected in the order dated 18/12/2018 passed by the ADC. The learned Assam Board of Revenue, in the proceedings before the learned Assam Board of Revenue, that is RA 09/K/2019, Nurul Haq did not participate And there was no representation on behalf of Nurul Islam. No, did not participate. The learned Assam Board of Revenue by an order dated 31/12/2020. It is not. It is relevant to take note of that an application was filed in the said appellate proceedings before the learned Assam Board of Revenue seeking impleadment, seeking substitution,
Yes, Lordship, and.
seeking substitution
Lordship,
of late Nurul Islam by the petitioners. The question of substitution did not arise. However, the said application can be treated as an application seeking impleadment. The said application was rejected by the learned Assam Board of Revenue, and the appeal was proceeded without hearing the legal representatives of late Nurul Islam. The learned Assam Board of Revenue passed the order on 31/12/2020. At this stage, this court finds it very pertinent to observe that the very appeal which was filed by late Kamala Devi Sarauge was a defective appeal, inasmuch as on the date on which the appeal was filed, late Nurul Islam had already expired. The judgment which was passed on 31/12/2020 by the learned Assam Board of Revenue set aside the order dated 18/12/2018 passed by the ADC. The petitioners herein thereafter also made an attempt by filing a review application which was registered and numbered as so and so. What number to question? No? The said review application was also rejected by an order dated 26/5/2025, 26/6/2025. And it is under such circumstances the present petition has been filed. This court have heard the learned counsels, senior counsels appearing on behalf of the petitioner as well as the respondent number 6, 7, and 8. In addition to that, both the Revenue Department as well as the District Administration have been duly heard. The sole question which arises in the instant proceedings as to whether the learned Assam Board of Revenue would have proceeded with the appeal against the dead person. From a perusal of the order dated 18/12/2018, it is apparent that late Nurul Islam expired during the pendency of the proceedings before the learned Assam Board of Revenue, before the ADC. What is the date of death?
19/10/2016. 19th of October 2016.
This aspect is further seen from the certificate issued by the register of issued by the this aspect is further apparent from the certificate, death certificate issued by the Department of Health Service, wherein it is mentioned that on 19th of October 2016, Nurul Islam had expired. Therefore, the filing of the appeal against the dead person at whose behest, in whose favor the order dated 18/12/2018 was passed, is apparently a defective appeal which the learned Assam Board of Revenue could not have proceeded with. It is the further opinion of this court that when the petitioners approached before the learned Assam Board of Revenue seeking substitution, the learned Assam Board of Revenue ought to have at least impleaded the petitioners to cure the defect. However, the learned Assam Board of Revenue continued to pursue with the appeal in spite of having due knowledge that the respondent number 2 in the said appeal had expired. Under such circumstances, the judgment dated 31/12/2020 passed by the learned Assam Board of Revenue, in the opinion of this court, is a non-est judgment. The consequential, it is also taken note of that even after filing a review application, the learned Assam Board of Revenue did not think it necessary for curing the defect by reviewing the judgment dated 31/12/2020. However, taking into account that the review application is dismissed, the challenge in the present proceedings is predominantly the challenge to the judgment dated 31/12/2020. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. The impugned judgment dated 31/12/2020 passed in case number RA 09/K/2019 is set aside and is declared to be non-est and accordingly set aside and quashed. Number 2, the appeal being RA number 09/K/2019 is restored to the file of the learned Assam Board of Revenue. Number 3, the application which was filed by the petitioners before the learned Assam Board of Revenue being registered and numbered as Madam, you are not ready. I think we should deliver the judgment some other day.
Lordship, page 67, last line, Lordship. The counsel for the respondent number.
What is the
2 had-
number?
Number, it was not mentioned, Lordship. Only the impleadment application by these 3 petitioners, Lordship, page 67.
You just check the file, na?
Number maybe. Only date is available 31/5/2019. Number detail.
It is not a substitution application, it's an improvement of legal aid. What are the names of the petitioners?
Ranima and Lordship, kindly page 68, Ranima Begum, Mohammed Aman Islam and Lija Rahman. The same petitioners in the writ petition, Lordship. Page 68, first 3-4 lines, Lordship. And application is dated, Lordship, 31/5/2019. Sometimes Revenue Board do not give the numbers in the missed cases, Lordship. Date yaad ase. Date to ase. Date to 67 page to ase.
Yes, sorry. The application so filed by the petitioners on 2/4/2019. 2/4. Under Order 1, Rule 9, Order 1, Rule 10, bracket 2 of the CPC, which was rejected by an order dated that application was not even rejected.
In fact, my lord, that was rejected on the, my lord, 31/12, that order only.
In the impugned order itself, Lordship.
Which was rejected by the impugned judgment dated 31/12/2020, is restored to the file of the learned Assam Board of Revenue. This court directs the learned Assam Board of Revenue to pass appropriate orders, thereby impleading the petitioners herein who were the applicants in the said application as parties in the said appeal. In a parties in RAK number so and so, 9 of so and so. Pustaka. Next. The what else?
My lord, we have to get implemented, my lord, because it the
It is also relevant to take note of that in the meantime, the original appellant, late Kamala Devi Saraugi, had expired, and the petitioner and the said appellant has to be substituted. Pustaka. Liberty given to the petitioners, respondent number 6, 7, and 8 in the instant proceedings, to file appropriate application in terms with Rule 19 of the Assam Board and Revenue Regulations 1963. Taking into account that the parties are duly represented, they are directed to appear before the learned Assam Board of Revenue on 30th of September 2026. In the meantime, the registry shall return the records to the learned Assam Board of Revenue forthwith, ensuring that the said records are available before the learned Assam Board of Revenue on the date fixed herein above.
Lordship, a little correction, Lordship, respondent number 1 and 2 were represented before the learned revenue board through council, Lordship. It is reflected in page 67, Lordship.
Oh,
1 and 2.
how can there be a dead person signing a wakalat number?
Lordship, that respondent number 1 was not represented. I have stated earlier that, but his counsel was there, Lordship. Nurul Haq, Lordship.
So it was not ex parte.
Lordship. And Lordship, may I pray to give a direction to do, to complete the appeal within a specific period, Lordship? 6
Why?
months, sir. It's a long pending case.
Why? It is now restored in your name. His name is struck off. Whose duty it is? If Mr. Chaudhary makes the submission, I would have been okay. But why are you asking? You got your order of Kamala Devi's AR being struck off. Your names are inserted.
Lordship.
It is whose duty?
my lord, while admitting the appeal, there was a stay of the my lord, the judgment passed by the ADC, my lord.
Stay there, he is honest. This cannot be a stay.
Abla-
তার উপর লিখে দিবা and the order dated 18/12/2018 revives restore করিস না declared to be non-est and accordingly the order dated 18/8 passed in so and so revives till the final disposal of the appellate order.
Or maybe my lord status quo till the matter is taken up.
Absolutely no status quo. You know nothing happens on the basis of that.
With Mrs. Chaudhary, my lord, things may happen. That's why.
Huh?
With her guiding them, my lord, we may be.
You will guide them to trespass.
No, no.
He's a senior counsel. Why will she do? This is a very serious allegation, Mr. Chaudhary.
my
You are
lord,
making upon a serious
My lord, I'm
senior
praising her
counsel.
intelligence.
We don't expect it from you. I
Yeah,
have
my lord,
understood with the junior counsel maybe
My lord,
enthused to make these type of submissions.
my lord, may I pray my lord, that let me be given a liberty to file an application for stay that will be not considered by the court.
Huh?
By the Board of Revenue. I can appear, my lord, apply for a stay of the judgment since it was there earlier.
Maybe Lordship, stay application is already there along with the appeal. Lordship, when the appeal will be taken up for consideration, they can pray for stay. Already it is there. For revival, they can pray, Lordship.
There should not be, my lord, multiplicity, that's why. There should not be multiplicity.
It is
of-
already in the file, Lordship.
Stands revived. 1812 stands revived. Thereafter, you know what to do.
Liberty to file application for, my lord, stay.
Application to assay.
As of now, you are nobody there. Are you there, anybody? in the appeal unless you get yourself substituted. Yes, tell me.
May I please, Your Lordship? My lord, this case relates to election of president, my lord, of Sri Bhumi Gaon Panchayat. After, my lord, the candidates returned, the first meeting, my lord, for election of the president and vice president was held on 3/7/25.
25.
Yes, my lord, 3/7/25. And in terms of the rules, my lord, that was done by way of secret ballot. Now, my lord, my lord, appeared that both the candidates, the petitioner and the respondent 6, my lord, they secured, my lord, 5 votes each. So therefore, my lord, there was an equality of vote. And in terms of, my lord, section 45, the election has to be done if, my lord, it is, my lord, then there is an equality. It has to be done by way of tossing of coin. And my lord, the
Tossing of coin not done.
it was done. The respondent 6, my lord, she preferred tail and I preferred head. Accordingly, my lord, the coin showed head and I was declared to be elected. Now, one document is very vital, my lord. Before tossing up, my lord, there was a resolution taken, my lord, recorded, wherein, my lord, both the respondent 6 and the petitioner, my lord,
Don't
signed.
say order.
My lord,
Which is the order?
order, my lord, before that, my lord, may I place one aspect of the matter?
No, not much. You are doing it on Tuesday, Wednesday. Show me the order. Where is the order?
Order, your
27E?
lordship will find.
You are challenging some 27E. Where
Yes,
is
yes,
that?
my lord, the order is at page 44, 27/8/25.
40? Got it. Okay, you filed an appeal.
My lord, what happened, my lord, the respondent 6, she filed a complaint before the district commissioner, my lord, disputing the result. And that complaint, your lordship will, my lord, will find at page 33A, my lord. That, my lord, complaint would be relevant, my lord. So I was trying to draw your lordship's attention to that.
So they applied 46(7)(b) and C and held that you did not get, you got 4 votes.
No, that's not the, my lord, that's
Yes,
not the
that's
issue, my
the
lord.
issue.
No.
Yes, that's the issue. Matter
Yes.
over.
That
Why
will
should I
reveal
decide?
No, my lord.
the order of the honorable court which I have approached, my lord, page 34, that will reveal everything.
My lord,
No, the order of the DC is clear.
Yes, it is clear, my lord, how it came.
DC has looked into it and found that there is an overlapping. So
Yes,
it
yes,
has
yes.
gone.
That, my lord, I have brought into record by way of affidavit, my lord.
Yeah.
My
my lord,
affidavit.
That case,
my lord, can I place my lordship will kindly give me 5 minutes time, my lord. My lord, the respondent 6, she agreed to go for the toss. She took the chance, my lord. And having found that the result is against her, my lord, she turned around and filed the complaint, my lord, at page 33, saying that there was no equality of votes. She received 5 and I received 4. And thereby, my lord, she filed the complaint. In the complaint, my lord, it was suppressed that there was a resolution, my lord, which I took your lordship's attention to page 33. This is important, my lord.
what is that?
Yes, page 33, this is the resolution.
So and so election of the president was conducted for both the parties and so secured 5 votes equally. As per the government guidelines, we have no objection in holding the election by lottery and we agree with one who will win. So this happened on 3/7.
My lord,
At that point of time, she did not look into 46(7).
No, my lord, that is not the case. My lord, what I'm trying to say, my lord, this particular resolution, that is, my lord, signed by the respondent 6 and, my lord, the proposer, my lord, as a witness, also the petitioner and the proposer in front of all the members and in presence of the authorized officer. She went for the toss. This particular resolution has been, my lord, withheld in the complaint, my lord, before the district commissioner.
So,
My lord, the district commissioner ought to have taken this particular aspect of the matter, that whether she can play hot and cold at the same time.
why didn't you place it?
My lord, I have placed it. What is, I have placed it. Yes, my
Not
lord.
here, there.
Yes, the district commissioner, I have placed it, my lord. The earlier order of this, my lord, honorable court, your lordship will find, starts from page 34. The respondent 6 appeared before this honorable court, my lord, alleging inaction on the part of the district commissioner. Now, this honorable court relegated the parties to the district commissioner for deciding the matter under section 11. The district commissioner has the power to decide the election dispute. Now, while
Now, first of all, who was declared by as the president?
I was declared. After the
Initially.
toss. After the toss, I was declared.
So there is a declaration by the authority.
Yes, authority.
Where is the declaration?
Yes, my lord, the minutes of the, my lord, resolution.
Where?
Yes, my lord. It starts from, my lord, page 22. Yes. It starts from page 42, my lord.
What?
Sorry, my lord, page
You
22.
cannot read him, Mr. Counsel, then only. Where?
Date of meeting, my lord, page 22, annexer to date of meeting 3/7/25, time of meeting 1 p.m.
3/7.
Yes, my lord.
This is where the authorized officer is there, na?
Yes, authorized officer. This is authorized officer, my lord. The vernacular, it starts, my lord, from page 26, my lord. This is the translated copy. And my lord, the result is declared.
The election of the following names left 3 months, so and so, so and so. Thereafter, in charge call the names of so and so, so and so, so and so. To those and all members.
Page 24, my lord. If your lordship comes to page 24.
So, preferred foil and so preferred foil. Thereafter, the so and so. You are Aisa Begum.
Aisa Begum, my lord. Page 24, if I take your lordship
So
to page
against that, an appeal was filed under section 11.
My lord, yes. My lord, in fact, what the respondent 6 did, my lord, disputing this position that there was an equality of votes, my lord, she filed the complaint.
An appeal.
Yes, appeal, my lord, under section 11. Let us take as an appeal, my lord. Now, in the appeal, this part was suppressed. She did not say that she agreed, my lord, for the
Whatever the
toss.
suppression. Suppression is for the deceased to look into. My
Yes.
question is, whatever may be,
My lord.
she did it.
She filed the appeal.
It is not even required because suppression or no suppression does not require because the authorized officer has already been recorded in the minutes.
Exactly, my lord. In terms of section 46(9), my lord, it has attained finality. This is my case, my lord. Lordship is absolutely correct.
Therefore, the question is
Yes,
whether the learned DC was justified
yes.
in arriving at a conclusion without taking into consideration the recording in the minutes that both parties agreed to go for a toss.
That is not, my lord, recorded. That is not recorded by the district commissioner. And my lord, this honorable court directed me to file an objection. In the objection, I had made it very clear that, my lord, the respondent 6 neither, my lord, revealed before the district commissioner in the complaint, my lord, that she agreed for the toss, nor, my lord, she revealed in the writ petition which she had filed that there was a resolution, my lord, between the parties. That was also suppressed. I brought it by way of an additional affidavit, my lord, this particular document. And she is playing hot and cold, my lord. She took the chance, my lord, to win the election. The moment, my lord, it went against her, she turned around and made the complaint that there was no equality of votes, my lord, and thereby filed the complaint. And now, after coming to the High Court, she has expanded, my lord, the scope of the complaint, saying that the coin which was, my lord, after tossing, the coin showed, my lord, tail, but it was wrongly recorded as head. This is not part of the, my lord, complaint petition before the district commissioner. For the first time, this has been raised in the writ petition, my lord. Playing hot and cold, my
So
lord.
anyways, whatever may be,
My
she
lord.
also agrees that the lottery has not been done properly.
Lottery is properly, my lord.
Now who is the president?
I am the president. He is challenging, my lord.
No. You are not the president after the DC's order.
There is a status quo, my lord.
Status quo, then given the status
I am-
quo,
I
how
am-
does you become the president?
No, my lord, the status quo,
We direct again votes.
My lord,
These only 10 members fight it out. Matter over.
the question, my lord, there is a point, my lord, lordship will kindly consider. My lord,
You don't have
46,
the majority now.
I have a majority, my lord.
Fantastic, go
Well,
there.
46-9, my lord, lordship will kindly see.
Oh, whatever may be.
46-9 says the declaration by the authorized officer, my lord, is final. 46-9. And the district commissioner, while deciding under section 11, has to give some, my lord, meaning to my lord 46-9. Now, unless, my lord, there are cogent materials, my lord, the district commissioner cannot brush aside the finality, my lord, of the authorized officer under 46-9. There is a resolution, my lord, that I have won the, my lord, election. And there are no materials. Now, your lordship will kindly see what the district commissioner has said. I'll just take your lordship, my lord, to the relevant part.
But the status quo has no relevance. We vacate the status quo.
If your lordship, my lord, set aside this order of the district commissioner says, my lord, lordship will
If
kindly see,
set
my lord.
aside not only that, the entire area, let it fresh election. Over. 2 to 6, I have all the power. What do you say, Mr. Datta? Instead of hearing the fighting and the bickering among
No,
this
one
council-
point, lordship will kindly, my lord, lordship will kindly settle one point.
No, why
Well-
should I keep on settling points?
No, no.
Enough. Today, for the day, I have already settled many
No,
points.
why the district commissioner is wrong, my lord? Why the district commissioner?
Not necessary. All matters need not be settled when Mr. Talukder appears.
My lord, no, I leave it to your lordship, my lord. District commissioner has passed this order in violation of the rules, my lord. At least he has
Okay,
to.
we will settle it in a much cooler environment during the December months. December.
My lord.
Let it come up in December.
Little bit earlier, my lord.
No,
Little
no,
bit earlier.
the winters have to be set in.
My lord, correct, correct. There are so many points, my lord.
I
I'll
have
place.
some urgency, my lord. Status quo be
Vacate it.
vacated, my lord.
Let
No,
us
no,
vacate it.
no.
Let them, let me
Status
enjoy.
quo,
my-
there cannot be the status. How can there be a status quo?
It
What do you
cannot
mean
be.
by the status quo? The status
Then-
quo has no
My
meaning.
lord, then lordship will stay the order of the, my lord, district commissioner.
Why should I stay? Whatever,
Then
if
you-
somebody is enjoying, let them
DC
enjoy.
has passed the order by
Then lordship-
reversal of the
No,
videography,
no,
my
no,
lord.
no,
That
lordship-
was, they are not silent, my
There
lord.
cannot be a status quo.
There cannot be, my lord.
There cannot be a status quo. That is the status quo as on today. What status quo? Status quo, Supreme Court has been clearly mentioning the status quo has to be specific. Status quo as on the date on which the election. Status on is on the date on which prior to the order passed by the DC. No, nobody. On the date on which the DC passed the order, then on that very day he became the president. And the moment there is a status quo order means what?
I'm the
That he is the president. We clarify the status quo.
No, my lord, lordship,
Lordship.
then lordship will kindly hear me, my lord. 10 minutes. my lord.
Yes, status
Yes,
quo.
against him.
Lordship
I'm the
Lordship will
president.
kindly hear me 10 minutes, my lord.
No, no. December. December we fix all
Then-
this matter.
Then, my lord, next week, my lord.
No.
Not today, my lord.
So
Next week.
therefore, the best way is to go for an election. What is the problem? You
Yes.
don't have anybody who likes you.
My lord.
You don't have anybody who likes you.
No, my lord, lordship.
It seems
kindly-
I'm saying that you have lost the confidence of at least 5.
My lord,
There are 10. You will give your own vote. Do you have the remaining 4 with you or not to make it 10?
Lord,
Have again another toss.
nowadays your lordship is aware, my lord. My lord, core pani college, my lord, we don't know. Nowadays, my lord, it is very difficult to say. Well, there are some points, my lord, I think.
Or,
lordship should-
your client thinks that investing upon Mr. Talukder is better than to invest upon the others.
No.
Something like that. Either of it.
My lord, for final.
What do you
disposal-
say, Mr.
my lord,
Doctor?
If your lordship, my
It
lord,
appears to be the
if-
reason.
if it cannot be taken up today for final disposal, my lord, can,
I think this is the status quo goes against you.
no, on the date, my lord, during the
You
course
got
of
the
the,
order when, Mr. Talukder, when did you get the order? You got the order on 5/9/2025.
clarified, my lord.
If you have got the order on 5/9/2025, that means and the order was passed by the DC on 21/7/2000. When was the order passed?
27 August 25.
27 August 2000. On that day, he has been
I'm the
declared to be the president.
correct, my
So
lord,
therefore, the status quo goes against you.
my lord, during the deliberation, my
In
lord,
fact, you are violating. If you the moment you are saying that you are the president, you are violating.
Yes, yes,
No, my lord.
contempt of court
My lord,
amounts to.
my lord,
Contempt, na?
Otherwise, my lord, I'm not pressing on to that.
My lord,
Lordship is aware, my lord. What is what?
my lord, Lordship will kindly take up the matter either next week, my lord, if not today, my lord, then Lordship will dispose it of. I'll, my lord, raise 2-3 points, my lord, Lordship will kindly consider
I
that.
have heard this.
Interestingly, the petitioner has filed another writ petition saying that we have not given power to our.
Ah.
Yes, yes, I have filed.
Obviously,
That
this,
day I
you
told.
cannot. Where is that other petition? Give the number of the petition. When? Okay.
My lord,
This
2359 oblique 26, my lord.
list
Till
this,
then, my lord.
WPC
Status
2356
quo be
59 oblique
modified, my
26.
lord.
not necessary. What do you want? The status quo is in your favor.
Yes, yes, yes.
And
Officers
if
are-
necessary, show the video recording.
Yes, sir. DC has seen my lord video record.
Okay.
DC himself passed the after perusal of the video recording.
My lord, Lordship will kindly take up next week and dispose it off, my lord.
Or
Any
today also.
It cannot be at your, we fix it today. We have already spent 2
Yes,
matters,
sir,
the
ma'am.
entire, today I'm having 71 matters because of you. This is the only simple case where there should have been a fresh election.
My
That's
lord,
all.
that part we clarified, my lord. Status quo means I'm the president. That part at least, my lord.
No, not necessary. I think the court has understood.
Otherwise, my lord, they did not give me full pleasure charge.
Very good. Don't do anything.
That may be
Okay,
given.
list this matter on next week at a date of the Thursday, 2 p.m. for final disposal. Thursday is 3rd, no?
My lord.
3rd is open or closed?
Is open. It seems to be open.
3rd at 2 p.m. for final disposal along with WPC. number.
2359 oblique 26, my lord. Deeply obliged.
I'm not extending the interim order.
No need.
This type of interim order is against you.
My lord, that will create confusion. Kindly, my lord.
Okay, then make it clear.
No, no, no.
Then also
Then
make it
no,
clear,
no, no.
my lord.
Then it be.
Make clear, my lord.
No.
They are taking advantage of it. Make
No,
clear.
my lord. Lordship will
Make it
finish it
clear.
off. My lord, next week, my lord. God bless.
We have given our share of his entitlement. And the union government now has not released the rest of the amount.
The union
Eh.
government made a party
Yes, my lord.
who is appearing for the union. You have paid how much?
My lord, we have paid 8 lakhs. This is the copy. We have paid, my lord, out of 16 lakh 78,000, we have paid 8 lakh 39,000.
And the remaining 8 lakhs is remaining.
My lord.
Yes, Mr. Gupta.
The funds have already been released to the state. I have been the instruction.
Can I have a copy of your affidavit?
My lord.
The present petition has been filed by the petitioner. Claiming an amount of rupees 8,39,496, which is pending payment after receiving part payment of rupees. Have you received part payment?
My lord, I have received part payment, but after receiving part payment, I have filed this petition.
Why haven't you mentioned that you have received part payment?
My lord, the liability statement, my lord, annexure.
Where?
Is annexure 1, page number 12, 11 and 12, my lord.
This is not 15 lakhs. Madam, I think it is wrong on your part.
My lord.
What you have mentioned in your affidavit is wrong then. This amount has already been paid.
Well, that's what we are seeing that.
See his liability statement. Kindly see page 12.
My lord.
Bill amount is 8,39,496. And so see your paragraph 6. You say that you have already paid 8,39,496.
Total bill value is given here 16,78,000.
Where are you getting from? He is also not claiming. The affidavit seems to be wrong. We have not checked it from his petition. No. The present writ petition has been filed by the petitioner claiming an amount of rupees 8,39,496 on the basis of a liability statement issued by the Office of the Executive Engineer, Gauhati East Water Resource Division in respect to the work pertaining to NIT/5/2011-12/26 dated 27/12/2012. Mr. H. Gupta, appearing on behalf of the respondents, number 6 and 7 have placed an instruction before this court which is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the central share in respect to the anti-erosion measures to protect Swalkusi town from erosion of river Brahmaputra phase 3 under the FMBAP scheme have already been released. This court have also taken note of the affidavit filed by the respondent number 3, which in fact surprises this court, inasmuch as when the amount claimed by the petitioner on the basis of the work order is rupees 8,39,496, it is mentioned that the petitioner's claim is rupees 16,78,752, and out of that, 8,39,256 have been paid, with a balance of rupees 8,39,496. And the said payment of rupees 8,39,496 is not paid on account of non-receipt of fund from the Ministry of Jal Shakti. The stand which has been taken by the State Water Resource Department not only appears contrary to the stand of the petitioner's claim, but also contrary to the stand which have been taken by the respondent number 6 and 7 in their instruction, which is kept on record and marked with the letter X. Ms. P. Chakravarti, the learned standing counsel of the Water Resource Department, submits that this difficulty has arisen on account of filing of the present writ petition after a lapse of more than 10 years. She, however, submits that an additional affidavit be filed after taking out after further reconciling the accounts. This matter again on 28th of September 2026. You should take always the plea. This is a 2012 matter. You couldn't have given it. These cases should be dismissed. How will you able to get it? That is the problem which has happened. I've recorded your submission without you making the submission.
My lord, in fact, we have instructed them, my lord, and then there is a direction from the chief engineer also that all these liabilities has to be countersigned by the chief engineer. Even then, my lord, we are receiving
No, but
My lord, I'll take up this.
what you have done is again wrong.
My lord, I'll take up this.
You say that there is no other payment. Matter over. The people who keep on sleeping, they are not entitled to a single penny. What is this? Power grid?
Lordship, the standing council power grid was just here, but he left for some domestic issue.
Is them, huh?
He left for some domestic issue.
Put the mic down, it is flexible. Yes.
Lordship, RK Talukdar sir was just here, but he just left for some domestic issue.
What is the matter about?
Worship, it's a compensation matter regarding right of way because of the transmission line drawn by the power grid.
Oh, is power grid the party? Who is paying for the power grid?
RK Talukdar.
Ms. So-and-so appearing on behalf of the respondent number 1 and 2.
1, 2, 3.
1, 2, and 3, 6 for 1, 2, and 3, 6 for an accommodation. List this matter again on 18th of September 2026.
Where please, your lord.
Yes, what is this?
This is the in the year 2012, lordship, there was an ethnic violence, lordship. Therefore, we had to go away, leaving our dwelling house and landed properties, lordship, to next nearby village, lordship. Again, after it became normal, in the year 2013, we came to our village at Mozabari and found that our land has been forcefully occupied by the non-tribals, that is the private respondents. This is a land which is
You are tribal.
Tribal.
Non-tribal are occupying it.
Yes, in belt and block area. Tribal belt and block. We have filed various representation, lordship, nothing was done. Now, if I may take your lordship to page 46, this is the minutes of the meeting. And lordship, one thing, lordship.
But why this is not a public interest litigation in a writ petition file?
This is not. Petitioners, their private lands have been occupied, lordship.
18 बदलाई दियो. No.
Because their private patta lands were occupied by the private respondents.
Whose patta lands?
These petitioners.
Huh?
Petitioners patta land.
So why should we initiate proceedings under this?
Now, lordship, if I may take your lordship to page 46, this is, and one thing, lordship, affidavit in opposition of
So your patta lands have been occupied by the private respondents. It's a civil dispute. Why don't you go there? Why should we take action?
Because regulation 167 put bar.
What?
Says, my lord, the respondent authority to pay the patta.
No, this is, that judgment is pertaining to Rule 18. This is 167.
Because Land and Revenue Regulation 1886 provides protection of the backward classes, and Regulation 167 puts bar on civil code.
For what?
In exercising jurisdiction in any matter covered by this chapter, including land and revenue, as per 6th schedule to the Constitution. Amendment Act 2003. BTC have been delegated the absolute power, lordship. So, therefore, we cannot go to civil court, lordship.
Lordship, may I submit, Lordship? In connection with this matter, this issue, Lordship, there are two PILs has been filed. One has been disposed of by the Honorable Division Bench, Lordship,
Yes, I know.
on 19/1/2026 regarding same issue, enforcement by the non-tribal this population
What is this?
for eviction. The-
That I have annexed, Lordship, at page 410,
nine-
1278 of the 2012, Pradut Kumar Bora.
and 22 of 19.
Pradut Bora.
Yes, what do you say? Respondent, private respondent? You can use the mic there.
That is due to ignorance, Lordship. That is due to ignorance. We are not aware of regulation 167, therefore, Lordship.
And during PIL, Lordship, already census was done, Lordship, and in that PIL census report was also there. And we are the parties, Lordship, 1964 we have purchased. Our predecessor purchased 1964. And his allegation is that, Lordship, we have occupied during ethnic violence 2012. 2012 ethnic violence, Lordship, non-tribals moved from Kokrajhar to some other place.
No.
The tribals, they did not travel from, move from the Kokrajhar, Lordship.
No, it is Chirang district, not Kokrajhar. Mozawari falls under Chirang district, not Kokrajhar. And Lordship, in PIL 78 of 2012, the division bench by order dated that I have annexed in page number 410. In my reply, that order dated 19/12/2019, at page 418, there is a chart which in BTC, which are the tribal belt and blocks.
But I think if these are dispute, yes, as regards the disorder, the deputy commissioner is required to take action.
Yes.
That is one aspect. If an action is taken, that is not subject matter of a civil court jurisdiction. But if it is purely a matter between so and so and so and so, then it will be the civil court.
They have already filed a suit, Lordship, for right title and khas possession, Lordship.
That I have stated, Lordship, due to ignorance.
Khas possession.
Anyways, we will think about it and dispose it of. This will require an authority pronouncement.
And I have included some of the registered sale deeds in our names, those were purchased before.
No, this is okay, but the fact remains, whatever may be. The question is whether prior to the tribal belt being created or not, these are things, many things which have to be looked into. I'm not on that. That can be looked into independently by the deputy commissioner. In view of the powers being given. If they don't take that power, it's a different aspect of the matter for which this court can exercise jurisdiction. But where it is a inter se dispute between two private parties, I think the civil court has to decide. The ousting of the jurisdiction in this section would not mean that there is an ousting of a jurisdiction in respect to the the other rights. Yes, it is the ousting of the jurisdiction is only qua the actions taken by the respondent, the DC in respect to the proceedings. This is what my belief.
Lordship,
What do
there
you
was a-
say, Mr. Sutia? You are also from the sixth schedule.
It is in some other cases also, my lord. Separately in Assam Land and Revenue Regulation, my lord, there is a specific procedure is there, my lord, for eviction of the tribal people, my lord, if, from the tribal belt and block, my lord. And in that case, your lordships, if it is dispute between the two parties, my lord, that the bar on the jurisdiction of the civil court, that is only, but if it is a dispute between the two parties, private, it is a private dispute.
If it is a private dispute, it's
And it
okay.
is a
But the
factual
moment
parties
the
required to be taken
dispute
into account.
encompasses the jurisdiction exercised by the DC, the civil court has to remove it.
Your lordships, if your lordship pass in judgment, it will, my lord, in our cases also, it will have some effect, my lord.
Because this is a very important aspect. Because
Important
otherwise it is the duty of the authority to do.
My lord, my
The authority, if they don't do, that's a different thing. But otherwise, if there is any dispute,
and administration of tribal areas, it is under my lord six schedule, my lord. Under the, we have, my lord, in Karbi Anglong, we have adopted the Assam Land and Revenue Regulation 1886. Chapter 10 deals with the backward protection of backward classes, my lord. For protection of backward classes, my lord, there are certain provisions are there. But if there is a dispute between the parties, the factual parties required to be determined, my lord, that determination can only be
done by the DC.
Not, my lord.
The DC can very well see as to the enforcement of that.
My lord.
But if there is a factual dispute as to whether his land has been occupied by so and so, because tomorrow, just forget about this. You tomorrow put a non-tribal in a shop in Diffu. And tomorrow the owner wants to evict him. So what will happen?
So that should
Then it should be referred to the the weak will lie.
No, my lord.
It has to be a landlord-tenant dispute.
Landlord-tenant dispute. And if it is a dispute between the two parties regarding possession, my lord, then it can be decided only by a civil suit. If it is a private dispute.
Civil dispute.
But if it is the government land, then only this rule will come into play.
No. If it is not over the government land also, in respect to other things also, the government also has the power. When the government exercises the power, then the civil court's jurisdiction is out. But when the government is not exercising the power, then the civil court's jurisdiction, the dispute between both private has to be decided by the civil court. I think that seems to be more.
There was a minutes of the meeting, lordship.
No minutes. We'll hear it and dispose it of one day on this line. Let me further think about it.
167 also very much clear. It says that no civil courts and exercise
Yes.
jurisdiction in any matters covered by this.
So therefore, it is the power exercised under this chapter where the civil court will not. But if it is a per se inter se dispute between so and so and so and so, this court.
Lordship may direct them to approach deputy commissioner and if
Why should I?
deputy
Why should I?
first and speaking order, then there is a dispute regarding title, then they can approach the civil court.
No, so therefore there is no bar. No, that is a direction I can give. But the bar, as regards the bar, one needs to make it clear that it would not apply qua of these two persons. Because it will have a far-reaching consequences.
Let the deputy commissioner decide at this stage. Lordship may keep it pending. Lordship may direct the deputy commissioner to give the status report.
Why should I?
To furnish the status.
Why should I ask the deputy commissioner to enter today between the two disputes?
No, because there is a letter, lordship, from the
whatever may be
Secretary Bodoland to
whatever
the
may be,
circle officer.
Secretary Bodoland writes. The Secretary Bodoland has no power over the DC. Do you have a power?
No.
DC and SP is outside the jurisdiction of here. And you have to understand that day I passed one judgment, interesting judgment to that effect, that though they have applied the Assam Land and Revenue for amendment of the year, they need an act. Because if you see in the state, in the district of Karbi Anglong, they have made an act which had the sanction of the governor, whereby it says whereby Assam Land and Revenue Regulation has been adopted, thereby changing who will be the other persons.
Yes.
Because the power here is given to the DC only.
Yes,
There needs an amendment for Bodoland Territorial Council,
correct, lordship is correct.
which is not there. So therefore, when do I dismiss your pet petition or pass that order? Any good date you like?
As per your lordship's convenience.
Not my convenience. Okay, list this matter on 5th of October, 6th of October. We'll hear you. I think this is a good case for passing an order. On hearing the council's list this matter on 6th of October for final
In
decision.
the meantime, lordship may direct the BTC to file.
Yeah, he has nobody. She is nobody here. Now, because you see, for them to come into the scene, there has to be an amendment to the Assam Land and Revenue.
Yes,
See, they have no business today.
The respondent will have to show, my lord, that they had got the prior sale.
Yes. And the minor has,
Otherwise, if they are encroaching in the government land, my lord, then they will go.
Whether they have a sale or not, have you taken action? My question is, have you taken action? If you have not taken action, don't raise that. You become a petitioner who, once you take an action, we will consider. And when she comes this side, we'll consider. But as of now, it is a dispute between him and him. Anyways,
the sale deed which was annexed lordship, it is signed by the minor lordship.
whatever may be.
That I'll
Minor,
show your
major, yeah,
lordship.
we'll finish it out on 6th. Hope I don't change my mind by then. Yes.
Obliged.
What is this?
May I please, your lordship? Lordship, the petitioners are aggrieved by the notices issued by the Caribbean Autonomous Council, Superintendent of Texas.
Ah, yes.
The lordship has filed.
Yes, Mr. Sutia, on the last occasion, I told you that there is a problem out here.
Lordship.
What you were saying that let
My
it be sent out there, it will have a far-reaching consequence.
lord.
So therefore, you have filed an additional affidavit.
No, I have filed.
Petitioner
your
has
lordship.
filed a-
I have-
petitioner
I have
has
filed
filed
it.
a- this one.
I have filed, as per lordship's direction, I have filed an affidavit, additional affidavit, placing the trade licenses of the petitioner as directed by on lordship.
Ah, your trade license are there. Huh?
There is the factual dispute between the parties, my lord, regarding whether they are within the Caribbean Autonomous Council jurisdiction or, my lord, in the Nagaon district. If they have any, my lord, any grievances, my lord, on the notice, my lord, they can, my lord, approach our authority also, then there is a factual determination, my lord. It can be disposed of like that way also, my lord. But under paragraph 10, my lord, we have enacted, my lord,
The
law, my lord.
problem lies that this power is being exercised by whom?
My lord, we have a exercise power under the, my lord, our act, my lord. Non-private,
Karbi Anglong, I understand, but the thing is the power is being exercised by some superintendent.
my lord, but
He has no authority in that. The authority will be of the circle officer. If you have a circle officer or
Assistant-
whoever it is.
yes, my lord, assistant revenue officer is
The
there.
ADC who can look into this aspect
My
and see as to whether it for their lands falls within so and so, within Karbi Anglong.
My lord.
So that is the only thing
My
which
lord,
can
my
be
lord.
done.
It can be referred to the not assistant revenue officer to the, my lord, additional secretary, revenue department or like that. We also to look into the matter, the factual disputes, whether it is within the jurisdiction or not, with the records and like that, my lord. Our boundary
We
notification
do
is also there.
having it matter after 4 months. In the meantime, allow them to participate, submit their documents before the ADC, the secretary, and let
Additional
him submit a
secretary,
report.
revenue department, my lord.
And on the basis of that, we close it.
My lord.
Because otherwise it will have, means,
My lord, my lord.
it will remain.
That the commission is
But
considered
here
only
he is
for the,
challenging these notices.
my lord,
And
issued
you
by
got
the
a status
taxation
quo.
department.
Yes,
I passed some order
My lord, not yet. my lord.
not yet.
earlier.
No,
Some
not,
order.
just lordship directed me to this file this additional affidavit, placing
Huh?
placing the.
Oh, last time I wanted to dismiss, na? You have
Right.
not include the
the
trade
trade
license.
license lordship.
The issue involved in the instant proceedings. is the challenge to the various notices issued by the Superintendent of Taxes, Karbi Anglong Autonomous Council, asking the petitioners as to what, asking the petitioner as to why action should not be taken against them for willful violation of Section 3 of the Karbi Anglong District bracket trading by non-tribal bracket close regulations 1953. It is the specific case of the petitioners herein that the petitioners herein are carrying on their business under the Borpothar Gaon Panchayat. And they have been issued trade licenses by the Borpothar Gaon Panchayat, which is in the district of Nagaon. It is therefore the case of the petitioners that under such circumstances, the question of the petitioner registering themselves under obtaining trade license under Section 3 of the Karbi Anglong District bracket trading by non-tribals regulations 1953 does not arise. In the opinion of this court, to resolve the dispute, there is a requirement of a verification to be conducted by the revenue authorities of the Karbi Anglong Autonomous Council as to whether the shops of the petitioner wherein they carry on their trade falls within the Karbi, which district? Within the Karbi Anglong district. This opinion is based upon the fact that merely on the basis of a trade license issued by the Panchayat authority or a notice issued by the Superintendent of Tax, Karbi Anglong Autonomous Council, one cannot decide as to whether the petitioner's business premises are within the Karbi Anglong within the Karbi Anglong district, Karbi Anglong, the district coming within the ambit of the Karbi Anglong Autonomous Council. This court therefore directs the additional secretary,
Secretary Revenue Department.
Secretary Revenue Department of the Karbi Anglong Autonomous Council, along with the District Commissioner, Nagaon, to carry out the necessary verification as regards the location of the petitioner's shops and thereupon submit a report before this court on the next date. List this matter on 2nd of November 2026. In the interim, no coercive actions be taken upon the petitioners on the basis of the impugned communications dated 5/4/2023 assailed in the present proceedings.
Deep privilege.
I think this is the only way out.
May I please your lordship, my lord? Lordship, the petitioner has approached before this honorable court, lordship, against non-providing of security protection to the applicant petitioner, lordship. Lordship, petitioner is a social.
What do you want?
Lordship,
PSO.
At least protection.
PSO
lordship.
is not given like this.
No, lordship.
Lordship, we have filed our affidavit indicating therein that there is no any threat
No.
Trade perception is not
There is
there.
something
That is why recommendation was
Lord-
against him.
Lordship
It
may-
was rejected, Lordship,
Lordship may
due to that
kindly-
reason.
Kindly come to page number, Lordship, 33 of my writ petition, Lordship. Lordship may kindly see the photograph, Lordship, how brutally he has been attacked, Lordship. 33, Lordship. The petitioner is a social activist, Lordship, and during his tenure, Lordship, he took some action against drug peddler, Lordship. And pursuant to this, Lordship, he has been brutally attacked on 24/3/2023, Lordship. Lordship may kindly see the photograph, Lordship. Thereafter, Lordship, he was admitted to
Have you been given the PSO till now?
not.
What are you doing till now?
Lordship.
This happened in 2023.
Yes, Lordship.
Way back, Lord.
Till
Now?
Lordship, not.
Any further attacks?
Yes, Lordship.
When?
Subsequently, also, Lordship. we have
After the
filed an-
filing of the writ petition?
Yes, Lordship. Subsequently, also, Lordship, we have filed an FIR, Lordship. Lordship may kindly.
FIR would not do.
Lordship may kindly. see the
FIR for what?
a reply, Lordship. In the
FIR
affidavit in
for what?
reply.
What do you do?
Lordship may kindly grant some protection, Lordship. I know, Lordship, there is some limitation, Lordship, but
He's a political leader, Lordship.
Got
We
a
have,
bullet and a pulsar bike and he parked his outside the gate of my house and the accused took out a sword, knife, like sharp weapon in his hands and shouts my name and tells me to come outside from the house and shout. The same persons.
yes, Lordship.
This is the same persons. All the along the FIRs are filed against these three persons.
Yes, Lord.
So you need a PSO for that.
They have not, and the state has not doing anything, Lordship. The state has not doing anything, Lordship.
So what has happened? State.
Lordship, in the
protection-
additional affidavit we have filed, we have annexed the
And Lordship,
trade assessment report, Lordship.
Oh, forget about trade. What are you doing to the FIRs?
FIR's Lordship, Lordship may kindly have a look. At
It's okay.
paragraph
You
5,
do one thing. You give an update on the FIRs. What has happened?
charge sheeted, Lordship.
That's it.
no, Lordship. This is another case, Lordship. In this FIR, Lordship, they are nothing to doing, Lordship.
Lordship may kindly have
And
a look at
if your
paragraph 5 of the affidavit in opposition we have filed, Lordship.
So Lordship may kindly see their affidavit,
Page
Lordship.
44, Lordship. Paragraph 5.
Mr. Counsel, the problem which arises is this court cannot direct giving you a PSO.
Yes, Lordship, I understand, Lordship, but the state cannot also, Lordship. So Lordship may kindly see the affidavit in opposition, Lordship, filed by the respondent, Lordship.
Huh?
If your Lordship may kindly come to the affidavit in not opposition, Lordship, how they are taking my case so, Lordship, casually, Lordship, page number 45, Lordship.
What is the last affidavit file? Let us see.
Last affidavit regarding, Lordship, threat assessment report.
Trade
Lordship.
assessment report, Lordship.
To allot
There is also nothing,
for
Lordship.
him at his own asset during the pendency of the.
Point number 13, Lordship may have a look.
There is no
Page
any
85.
specific threat found, but the applicant informed regarding his threat from the opposite parties by so and so, so and so, so and so.
Very
Yes,
next
a
page,
case has been
18 also,
registered
Lordship.
under so and so, so
Point
and
number
so,
18
so and so.
But no inquiry has been made, Lordship.
There's no any specific threat and PSO not recommended.
Without doing any inquiry, Lordship, they have
It is based on inquiry, Lordship.
made this threat assessment report, Lordship. Lordship may kindly
Not
protect us
satisfied.
something, Lordship.
Let me dismiss it in your hands of your senior. Not satisfied.
Because, Lordship, the state is also bound to protect the people, Lordship.
What?
The state is also bound to protect the people, Lordship.
They will protect, but not
No,
with the
Lordship,
PSO.
not required, Lordship, but Lordship, some protection may be given, Lordship. Kindly.
But everybody will say. What do you do?
So I'm a social activist, Lordship.
What social activities you have done?
He has some political
is-
affiliation
no, Lordship.
also, Lordship. In
Huh?
the report, that is clearly
Lordship,
indicated,
may
Lordship.
kindly-
Additional affidavit we
Lordship,
have filed.
kindly see, Lordship, page number 13 of my writ
Point
petition,
number
Lordship.
3 clearly reflects, Lordship.
Political affiliation with what?
Uh,
It was
Wa-
earlier,
one
Lordship.
one particular Political party, Lordship.
It was
Which
hard.
department? Which political party?
Assam Jatiyatawadi Yuva Chakra.
Earlier, he was holding the post. Lordship.
Point number 3,
Now
Lordship.
there is-
Page 85.
Huh? Political leader.
Political
No,
leader.
Lordship. Earlier, it was
As per the report, Lordship.
Now you are not no longer there.
No.
So there is nothing, no problem.
Lordship.
As of now,
But
there is no any threat. So as
No,
to
no,
warrant
Lordship. There is a
inspe-
threat, Lordship.
influence
These
of
are all parties which have happened in 2014, 2023 and 23.
way back,
We
Lordship.
are in 2026. Satisfied. When do you want the dismissal? This matter on some other judge will, kind judge may help you out. 16th of September 2026.
Bless.
In my hands, you are not going to get it.
Bless.
What are these?
Your Lordship, the respondent number.
These are unauthorized construction, Lordship, once against each other, Lordship. I mean, two matters are there, one against each other. Lordship, in the first case, Lordship, they made one complaint that the adjacent building was unauthorisedly constructed. It was sealed by the authority, but subsequently they again started construction. We made an inspection and we found that it is still under seal. So there is no question of, so far as the allegations in this first petitions are not correct. And so far as the second is concerned, Lordship, herein we have filed our affidavit. But on the last affidavit, in the last affidavit, Lordship, we have stated that we are going for inspection of the building and then file one, affidavit apprising this honorable court about the same. Lordship, today I have been informed that inspection has already been done, but that report has not yet been furnished to me, Lordship. In the second case.
It's the, what about the first one?
First one, Lordship, herein, Lordship, they allege that building which was sealed by the authority, Lordship. The
Whose building?
I mean,
Your
his
building has been sealed by you.
It is already
They are
under.
still constructing after the sealing.
Yes.
Then
We made an inspection. We found that no construction has been made. It's still under, sealed, Lordship. So far as the allegations in these petitions are not correct. That is one hearing. In the second one, Lordship, I'm waiting for the inspection report.
the PNAC, the Learned Council appearing on behalf of the AMC and the GMDA submits that an inspection was carried out in respect to the building of the petitioner in WPC number 6752/2025, isn't it?
Lordship.
Of the petitioner in WPC number 6752?
Yes.
Whose building? Manoj Kumar Singh's building.
Yes.
And after inspection, a report have been submitted before him, which he would like to bring on record by filing an affidavit. This matter again on 23rd of September. In the meantime, the said affidavit be being brought on record.
Very good for you.
Why is the court being involved because of your actions? You have the power to do whatever you will feel like, unless the power has been illegally exercised. Yes.
Please, Your Lordship. Lordship, regarding these two matters, Lordship, we have filed our affidavit in opposition in reply today, it's a Lordship. Let the
Which one?
Lordship, in item number 37, Lordship, we have filed an affidavit in opposition, and in 38, an affidavit in reply.
Learned Council appearing on behalf of the respondents in WPC number 2620/2024, who is the petitioner in WPC number 36/2009. No, which one? First piece, which one?
First was, Lordship, item number 37, Lordship, we respond number 5.
What is the number?
Lordship.
2620.
2620, Lordship.
2620/2024. submits, who is the petitioner in WPC number 36/2019, submits that an affidavit in opposition has been filed. Further to that, the learned counsel also submits that in WPC number 36/2019, an affidavit in reply has been filed. So the registry shall bring on record those documents. Those pleadings. In the meantime, the petitioner is granted the liberty to file affidavit in opposition in WPC number, affidavit in reply in WPC number 2620/2024. You are Debesh Bosumata. Is this matter on 28th of September 2026.
Obliged.
Yes, what is this
Documentally
Lokhipu
stated
municipality, wherein
seven-
the petitioner is in possession, does not fall in, oh, this one.
Note 17(8) order में can be seen note.
There we can't finish it off. We finish it off on another day. That day did not reach, na?
Note.
Let's have it on 29th. At the top of the list to finish it off.
Note.
And nothing else, only thing I have to give the liberty out there to whatever it is.
Note.
Because the settlement has not yet been granted to you. So you don't have the authority, it has to be done through the government.
And
It
in
will be
fact,
done
Lord,
through the government.
in fact, the board, the Lokhipur Municipal Board, they have requested the circle officer to show if he is in the other duct, show us our duct. That request we have already made.
No, so therefore they can very well take it. Now it is
Mother.
being reserved in your favor. The circle officer can very well take it by taking notice, issuing notice and finishing.
So that observation, this matter may be this.
Understood, but then also one has to write, no? Yeah, there are so many matters to deal with.
Much.
Taking into account that the matter has been heard in the entirety. List this matter on 8th of September 2026 at the top of the list for final disposal.
Obliged. But in item 22 and 23, I have given.
Yeah, who is there?
DC. In Borpata, there is no, till now, there is no nomination.
Then in that case, I am right. Hetu thol ki implement application kiyon allow kori diyo. So yet duta ho. In this case duta allows. Is the DC there, na?
Till now, as on today.
It's okay.
Not
Then because the direction was to the DC.
Not
And in the meantime, get the speaking order passed.
will do. I have spoken. On it.
What is this?
Non-payment of lease loss.
Also, in this case, the APIDA is the funding agency and we are the ASME is the executing agency, Lordship. Lordship,
who is to pay?
Lordship, what happened in this case, work order issued in favor of one IS stating, but the petitioner is again referring. Work order issued in favor of page 25, Lordship. Work order issued in favor of one Messrs. IS Trading Company, Silver Square Building, Gauhati.
Then
the petitioner is Lordship one JK Trading, Lordship.
Who are you? With reference to the above, this is to inform you that your proposal to give the subcontract to to complete the work so and so is hereby accepted.
Lordship, what happened?
Page 26.
And Lordship, what happened in completion certificate, Lordship? Page
34.
Page 34. The column 4, accepted contract price is 12 crore 21,26,438.
At serial number.
And serial number, it is value of work done is 12 crore 42,59,679. So we are examining this is whether is the entire work has been completed or not. So some time is required to verify this.
You verify, examine, whatever you feel like do. and thereupon pay within 6 months.
Lordship, may kindly see page 56, Lordship.
Matter can't give.
Page 56, their admission is there, Lordship. Page 56, Lordship.
What
Sorry,
is that?
46, Lordship.
Page
46, Lordship.
Lordship, he
It
have
is
annexed
46. What is
annexed this
that?
document, but they have not.
What is pay period?
Page 46, Lordship, may kindly see.
What is this?
This is, Lordship, regarding a reply, Lordship, where serial number 2 is the work regarding the present work, Lordship. Serial number 2.
Non-availability of fund.
They are admitting that 27 lakh.
So they have said that as regards JK trade, how much is remaining?
27 lakh, 93,000.
Only 27 lakhs is remaining.
And I have also
According to
taken-
them, so let's say we are examining it, so some time is.
Obviously, you examine, verify, and then pay. You have already paid them 12 lakhs,
Part payment is made.
14,000. And apart from that, when you have paid 12 lakh, 14,000, 12 crores, na?
The funding, Lordship, the funding agency is appeal, so.
Understood. 12 crores is the total amount.
Lordship,
Out of that, if we take the 10% or the other, I think they may not be entitled to any amount.
Lordship.
This might be the deduction of tax at source also. You never know. Look into it. Because here the 27 lakhs, we are concerned about
27,
12
93,
crores.
93, 170, they claim, Lordship.
Huh?
Now
I'm
they are
also claiming
claiming
only the-
27 lakhs, 93,170 rupees they claim.
Understood. So you kindly look into it, verify, and if necessary, if he's entitled to pay within
Yes,
6
Lordship.
months.
Obliged, Lordship.
Established.
My lord, we have filed one affidavit in reply yesterday. It's not updated.
What remains in this case? Nothing out there. You will be given whatever maybe by my amount will be returned and everything. On the last occasion, I only told you, your Mr. R. Shekhar only said that let me get an instruction. I've only come to know today. So what remains? There's nothing out there.
Termination of the petitioner, my lord.
So what? For that, if it is a termination, you were a party to that. You have also visited out there in the minutes.
No, madam. So
No.
far as this minor is concerned,
Ah.
my lord, petitioner is not there. Because there is no
Yes,
direction of the honorable court to allow the petitioner to be there. It is an administrative decision at the highest level. And my lord, moment the termination order is issued, it's up to him, he may take his call. That's a
You take
different
an
issue.
action out there.
Not been notice. at this point.
They are not issuing a termination.
It will be, my lord, because it is pending, my lord, otherwise decision has been taken.
We record it, that you can issue, then we close it and then ask him say to be infructuous and then allowing him to terminate. Because today I can't say, you may
Yes.
not issue.
Lordship. To act upon the minus of the meeting, my lord, that liberty may be given by.
Mr. B. Gogoi, the learned counsel appearing on behalf of the petition respondents, submits that although there is no stay order passed in the instant proceedings, but the respondents, before taking any action on the minutes of the meeting, would like to apprise this court. Taking into account the decision which has been taken, which is not a subject matter of challenge in the present proceedings. This court finds no bar on the part of the respondent authorities to take consequential action on the basis of such decision taken on 29/6/2026. It is however observed that in the circumstance such decision is taken, it shall be always open to the petitioner to assail the same. When do I fix it?
In that case, after 4 weeks, my lord. In the
Okay,
meantime-
leave this matter again on 30th of September 2026. Review has come. What is the review sought for?
But we have sought for review of the Honorable Court order dated 28/1/2019. That is at page 16. Malad.
What is the direction?
Direction of the Honorable Court is
Directed to pay the due compensation to the petitioner for acquisition of 3 bighas, 15 lechas of land.
Malad.
In a period of 4 months from the date of receipt of a certified copy of the order. Needless to say, the petitioner would be entitled to solicium and statutory interest along with so and so. Now, as per your thing, his land is only limited, the land which have been acquired is only limited to some
4 katha 15 lecha.
4 katha
15 lecha. Malad para 4 में kindly see. Malad.
out of 5 bighas of land. Matter with the right to copy.
Oh, I can ask that.
You have filed affidavit, Mr. Sakya.
Yes, my lord.
How much is your land?
My land was 3 bigha.
What is your basis?
Because my lord kindly see my lord, the original, my petition, my lord.
Now forget about repetition. My question is, what is your basis to claim that you are the owner of 3 bighas?
My lord, they themselves have in the gazette notifications admitted.
Gazette notification which have been issued is a notification under section 4 or section 6.
Yes.
Section 4 is not, cannot be said to be conclusive. Section 6 is only merely a declaration that they intend. On the basis of a gazette notification, it cannot be decided. The decision has to be only by way of either by the district commissioner at the time of passing of the award or at the time on which the reference court decides. Now, in this case, the question is, they now say that you are entitled to only 4 katha 10 lechas.
They say now.
Now say, on the basis of a circle officer. And they said this is the amount of rupees 2 lakhs so and so which is there. Okay. Now, this is an acquisition done under the 1894 Act.
Yes, Lord.
So we do one thing. We direct, you take that amount. Take that amount of this 2 lakhs.
First, I will make a submission, Lord.
Wait. I'm just making my suggestion and then you think about what is to be done.
My lord.
You take the amount of this rupees 2 lakhs because it is otherwise lying out there. Secondly, there are 2 aspects. total 5 biga 4 katha 10 lectures were acquired. That is the total acquisition.
My lord.
Now, in that regard, there are 4 aspects which can be adjudicated by the reference court. First is the inadequacy of compensation. If the compensation is less, you can very well challenge it in the reference court. Second is entitlement of the compensation, meaning if you are entitled to how much it is.
My lord.
Third is apportionment of the compensation, means in respect to 5 bigas, 4 katha, 10 lectures, if you are entitled to not only 4 katha, 10 lectures, but you are entitled to more amount out of that, because it is a total corpus. If you are entitled to more amount,
My lord, that is
so that can also be decided by the reference court.
My lord, but
And the fourth is as regards the measurement of the land.
my lord.
Now, the measurement of the land is not the question out here. Inadequacy may come in. Apportionment of the compensation may come in.
Lordship, that is first it is decided whether it is the 4 kotha or 3 bigha. My lord, kindly see their own admission. Page.
No,
They themselves have
When
admitted.
they have filed the review application and this court has issued notice, you see, whatever may be.
My lord, just a minute. Kindly see at page 15 of my writ petition, 6160. They have admitted they are Advocate General. Page 61 or 6061, writ petition and page 15.
Page?
Page 15, my lord.
15, yes.
Because these petitioners came twice before the Honorable Court. Page 15, Lordship will kindly see page relevant portion. Well, my lord, page 17, bottom portion. 17. Mr. Soika, Landed Additional Advocate General, publishing the record relating to the payment of compensation, has submitted that in fact the acquisition compensation in respect of 3 bighas 0 kotha 15 lectures of land had been paid during the lifetime of the petitioner in interest of the petitioners, which was received by the Tara Prasanna Das and Sakrakanta Mehta. They having been authorized to receive the compensation. Mr. Soika therefore submits that petitioners are not entitled to any amount of compensation in respect of 3 bighas 15 lectures of land. It has also been submitted that since the claim of the petitioners relating to 2 kothas, 3 lectures of land is a part of disputed question, the relief claim in the present petition may not be granted. Yes, we have abandoned that action. Now, Lordship kindly see. Next paragraph, page 18. It is not in dispute that the land measuring 7 bighas 2 kotha in Dag number 338, Patan number 9 of village Ulubari, Mojo Ulubari in district Kamrup, Assam, apart from other land, was acquired for a public purpose, registering allocation number iman. Out of the said 3 bighas 0 kotha 15 lectures was acquired from the petitioner in interest of the petitioners. As noted above, the grievance of the petitioners is relating to the non-payment of compensation in respect 3 bighas 15 lectures land, though the learned Advocate General by publishing 2 registers has contended that the amount of compensation payable for acquisition of the said land has been paid to the petition interest of the petitioners.
Mr. Saikia, Mr. Saikia, I have read it.
My lord.
I'm telling you.
My lord.
Neither me writing out here that you are entitled to 100 bighas or 5 bighas or 4 kathas would give you a right as regards 4 kathas or 100 bighas. When it is a case of public money to be paid, it has to be on the basis of necessary papers. Now, the review has been filed to the extent that your entitlement actually is of 4 katha 10 lectures. Satisfy me with the particular document that you have entitlement for 4 katha 10 lectures.
That's it. That is
3 bighas 3.
My lord, kindly see their own page number 23 of their affidavit, review petition.
I'm telling you that affidavit
Their
is not
calculation
making
itself
sense.
is wrong. That they have shown 4 kotha by giving a wrong, they have kindly let my lord, page 33, they have given their own statement, page 33 of the review petition. Page 33. I have calculated at my home thrice. Page 33 of the review petition. How they are 4 kotha It is more than 2 biga 4 kotha. They, as per their own statement. Page 33, my lord. They have given that the land has been transferred so and so to those persons, and this I calculated as per their own. It comes to that more
What
than
is
2
this
biga
page
4 kotha.
33? Which one page?
Page 30, page 23 of their, my lord, review petition.
Yes, 23. What does he say?
Kindly see, my lord. How they have calculated. They have given the translated copy of the Jamabandi at page 23, and they have given a calculation, and I have calculated at my home.
Where?
My lord, they have given a calculation and said that 4 kotha only was acquired. Now, but if I calculate this, I have found it is more than 2 biga 4 kotha as per their own Jamabandi, own statement. I have calculated more than 3 times. Let them calculate, my lord. Their calculation is wrong. And they have given the Assamese copy also. They said that these lands were sold to so and so persons before acquisition. If it is true, for a argument's sake, let them, my lord, it comes to more than 2 biga 4 kotha have been acquired by them out of 9 biga 1 kotha.
Total, how much is the land?
Total 9 biga 1 kotha, my lord.
And we are concerned with which dag?
My lord, dag number 338. 338, my lord.
But I have the original certificate. This other
Oh, it's okay. My question is 338.
338, my lord.
Where is 338?
My lord, at page 22.
338 is how much?
338, there was 9 biga 1 kotha.
Ah.
They themselves have admitted in their own petition, my lord. Kindly see that they said that is 9 biga, and also notification also 9 biga 1 kotha, my lord. Just I am placing it.
It's understood. Now let us see one thing.
Let it be calculated properly, my lord. Let it calculate them. In earlier two writ petitions, they admitted that is 3 biga 15 lessons. Now, with different pleas, they are coming. Once they will say one biga only in Assam Tribune they published, that was rejected by the Honorable Court. Once they will say this 4 kotha, but calculation is wrong. Their own calculation, my lord. Lordship, page 8 of the review petition. Page 8 of the review petition, my lord. That is, they have given the land. Total area of land, tag number 338, pattern number 9, 9 biga 1 kotha 0 lessa. It is correct. 9 biga 1 kotha 0 lessa. Then they have shown that the petitioner's father have sold the land at page 23. If we admit these things, though it is not substantiated by any sale deed, if we even accept it, it will come to be more than 2 biga 4 kotha have been acquired by them.
Mr. Nath, tell me. Total In Dag, patta number 9, Dag number 38 is 9 bigha 1 katha.
Lordship,
Area of the land acquired in Dag number 338 is patta number 9 is 7 bigha 2 katha.
Lordship, Lordship.
Meaning thereby 1 bigha, it's a 1 bigha 9 lechas, 3 lecha, 3 kathas. 3 katha almost?
Lordship,
4 kathas.
Four
1
katha.
bigha 4 katha
Four-
remains
4 katha
in
remains.
Dag number 338.
Lordship, that is not an acquisition.
Now, share of the above pattadas, why 5 bigha 4 katha?
No, Malad, in the acquired land, out of 7 bigha 2 katha, the share of the pattadars is
Who are the pattadas?
But we have indicated, Malad. Kindly come to the previous page, Malad.
Yes.
Out of total, paragraph 4 last sentence, Malad, out of total 5 bigha 4 katha 10 lecha, altogether there were 14 pattadars. Their respective shares are as follows. In the name of Moidur Rahman and Azimuddin Ahmed are found in the Jamabandi, but as per report of the Circle Officer Gauhati, their share of land does not fall in the acquisition. That is the one bigger land. Share of 2 katha, 2 katha, and 2 katha 10 lecha respectively. Again, it is to be mentioned that 1 katha 5 lecha belonging to Nirbhoy Bormon and 1 katha 10 lecha belong to Bibhas Chandra De. Total measuring 2 katha 15 lecha as per report of so and so. So, Malad, we have Nirbhoy Bormon and Bibhas De. We have that
Understood.
2 katha 15
All
lecha
are
belongs to-
understood.
Logic.
My question is, you are taking 7 bigha 2 katha.
7 bigha 2 katha.
You are acquiring.
Malad.
The out of 338 contains 9 bigha 1 katha, which means 1 bigha 4 katha remains. Out of this 1 bigha 4 katha, the share of Moidur Rahman and Azimuddin does not come, which means they must be coming within 1 bigha 4 katha, which is to the tune of 4 katha 10 lecha.
Malad.
Of these 2 persons is outside.
Outside.
That the land measuring 1 bigha 5 katha belonging to Nirbhoy and 1 bigha of Bibhas,
That Malad we have
which is 2 katha 15 lechas.
2 katha 15 lecha.
Now, that be so, 2 katha 15 lechas. Why are you subtracting, only making it 5 bigha 4 katha 10 lechas?
Malad,
Because the total land is, my understanding is difficult to understand.
logic.
Total being land is 9 bigha 1 katha. You have only acquired 7 bigha 2 katha.
Malad.
And out of this 7 bigha 2 katha, this particular land of 1 bigha 4 katha is with those 2 gentlemen, Mayud and Azimuddin.
Yes.
Nirbhoy and Bibha's share is only 2 katha 15 lechas.
2 katha 15 lecha.
So, therefore, you subtract 2 katha 15 lechas from 7 bigha 2 katha.
Logic.
Okay. So, it comes to 6 bighas, 4 katha, 15 lechas. Why you are getting 5 bigha 4 katha 10 lechas?
Malad, in fact, in the acquisition, the 5 bigha 4 katha 10 lecha is the share of the pattadars.
So, if it is the share of the pattadas, how can it be? But if you are acquiring because unless you show the 338 is in a patta, so obviously it can't be a government land.
It is in patta.
So if it is not in a government land, obviously they have a share.
Malad, before acquisition, they have sold the land to many of them.
Understood. But if I see that particular thing also, at best it can be only 2 bighas. Nothing more than that.
Malad,
See that? I have seen page 23, 24.
Malad, Just I'll reconcile, I'll place.
It doesn't appear so.
I'll reconcile and place.
It seems there is a wrongful calculation.
No, I'll reconcile one.
This doesn't say.
I'll place one.
The problem arose because of this. Writ petitions should not have been entertained in 2012. It should have been immediately sent to the reference court. Go there, fight it out. This is not the way. Problem lies because of this entertaining this type of Full stop. This matter. I think you ask your circle officer to do the calculation properly. He doesn't seem to be done it properly. And have to look into it in each of the columns, how much it has been transferred, and look it also analyze, not on the basis of the cheetah notings. You have to also note it out there with the connected mutation proceedings. Then only you can guide an idea, because overall they were the original patadas. They have sold the lands. As per them, they have not sold any land. Anyways, there appears to be a fundamental mistake in your calculation, because you have taken 4 katha 10 lectures of those two gentlemen inside. And if that is not a part of the acquisition, then they should have been within the ambit of 1 katha 5 lectures. Of Anbika 5 lectures, 4 kathas.
So Nirbhoy Varman and Vivas they were there, man.
Understood, but their limited is 2 katha 15 lectures.
Katha 15 lecture. That's true.
We have to take 2 katha 15 lectures out of 7 bighas.
I'll reconcile. I'll reconcile.
So therefore, 5 katha 4 lectures, 5 bigha 4 katha would not. Anyways, chalo. When do you want?
But let's give me 1 week.
Let Mr. Saikia not be troubled any further. Isn't it, Mr. Saikia? I should not trouble you any further.
My lord, what happens, your lordship is correct. But the calculation, they have given wrong calculation. Their own statement.
Their calculation is apparently.
I have calculated at my home, along with my daughter also, and one mathematician. They kindly calculate a retired headmaster, and he at the long run they are also own their own statement, my lord, showing the sale of land. It comes more than 2 bigha 4 kotha.
Yes.
So secondly, my lord, the Honorable High Court twice has the final judgment has.
Mr. Saikia, I understand.
I have filed this.
You have to also understand that for the review, there has to be an error apparent on the face of the record.
My lord.
If they can very well clearly show to me that
My lord.
yes, it is a case of that, then only I will review.
My
Otherwise,
lord,
no.
my lord. And second submission will be, my lord, lordship is very much aware that since no award was passed to us, no compensation was paid to us, the Honorable High Court twice held that no compensation was paid to them. That as such under the law, I am entitled under the new act. That is why I filed this case.
You are not entitled to your new act. You will be entitled to compensation.
My lord,
at the
this
rate
is
of
the
50%.
this is the law, my lord. This has been this law, this Assam, this right to fair compensation.
No.
My lord,
Possession has been taken,
once-
Mr.
once
Counsel. Mr. Senior Counsel, possession has been taken. That is the judgment of Indore municipality.
What compensation is not paid at all. Lordship,
Whatever may be, you see the or which was there in 24B has been made as end.
no, I have gone through this book, Lordship.
No, but don't look into the book. You look into the judgment of the 3 judges or 5 judges, this Indore municipality. 3. Look into that. Mr. Borpujari will provide the judgment.
Borpujari, kindly give me a copy. I will go because I have to satisfy my, because this is more than 50 years, my lord, old case.
Okay, well, I think
50
we
years ago, land was
we
declared.
will finish it up. Don't worry. When you will
Lordship may keep it after a week, man. I'll reconcile the.
release this matter again on 9th of September 2026, on which date Mr. Inath shall provide an accurate calculation
Of the land. Lordship.
justifying the review application.
Lordship.
Our land is wrongly classified as ceiling surplus land. Our land is wrongly classified as ceiling surplus
We
land.
found we have to make necessary correction of the records. Yes, correction done.
As per page number 26, if you see, Lordship,
Records have
it's
been
the order passed by circle officer.
an order.
When it is stated that the land is free from ceiling surplus, but till date the correction has not been done yet.
Understood. I passed a detailed order on
Lordship,
77.
Lordship.
What is your instruction?
No, Lordship, we have not received any instructions, Lordship.
Which deputy commissioner?
Kamrup. The office is shifted to, because of that, most probably.
Is the circle officer, Dispute Revenue Circle?
Yes.
A final opportunity is granted to the circle officer, Dispute Revenue Cycle. To file the affidavit. Providing his reply to the queries raised by this court, reply to the affidavit in opposition to the writ petition, including the queries raised by this court in the order dated 17/7/2026. The said affidavit be filed on or before 23rd of September 2026. List the matter on 30th of September 2026. It is observed that if the affidavit is not filed by the respondent number, the number of the respondent,
Circle officer, Lordship,
4.
4.
4. The respondent number 4 shall be present before this court at 10:30 a.m. to the video conferencing link to be provided by Mr. H. Sharma.
Lordship.
List.
Lordship, in writ petition number 7013, petitioner was directed to file before the.
What is
circle
your
of-
case?
One case is that there are two cases. One is for enhancement, Lordship. The complaint, the representation was submitted on 21/9,
Award passed?
not yet.
Then why are you asking for the amount?
And another one is that he has not even received the compensation. There are two cases, Lordship. 7013, after filing the writ petition, DAG number, Lordship, 519, he got it. After filing the writ petition, he had received that amount.
Which one?
In WPC, Lordship, 7013.
7013.
Yes, Lordship.
What is your prayer there?
There is for compensation, Lordship.
Yeah, should not be, should to pay the compensation. You have got the money.
Yes, I have received, Lordship.
The amount, this has gone.
Yes, he has received.
So it has become infraction.
Lordship, but it was delay, then it's a delay because land was acquired in the year 2018, Lordship. And he has received after filing this writ petition. After he filed it, then he received the amount. So 9%, enhanced amount, he was supposed to get interest per year, Lord.
Why? Is it the same land? The next writ petition?
Yes, yes, Lordship. That is, he paid for enhancement.
We do one thing. We
Yes,
close
Lordship.
this first writ petition unnecessary. There's already become an infractions. You have got the money.
I have got it. And then in that they have filed a reply, Lordship, wherein they have said that there are two DAGs. One is 519, one is 366. In 366, they said that they don't require such land. So what direction was given by this honorable court to the petitioner to ask for, but till date, we have given the representation. It's just day before yesterday only, Lordship. Representation for handing over the land which is not required. Because in DAG number 366, it was 4 bighas.
Has the award been passed? Yes. Award passed.
Lordship, regarding that one land, Lordship, that is DAG number 519. In that case, Lordship, the amount has been paid. And regarding this DAG number 366,
Is acquisition made under what provision?
And compensation is as per the new act, 2000.
It's okay, I'm not on that, but acquisition made under what provision? Where's the award?
your Lordship should the de-acquisition order, your Lordship will get it and annexure
Where's
B.
the power of de-acquisition? De-acquisition? Where's the power?
That's because when the land is not required, Lordship.
You cannot. How are you de-acquisitioning this power? The land having been vested upon you? That is why I'm asking you. Is it ever heard of? Whatever you feel like doing it. One, you issue a de-acquisition. Show me the power of de-acquisition. Mr. Borbuzari, give a training to all the revenue
Assam.
people. They don't know head or tail about law. Law is this door. Your revenue officials is that door. What is the power under 64 Act permissible? No. Then, because by virtue of the notification issued under Section 6, the land vests upon the state. Yes. Whatever you feel like they keep on doing. This district commissioner, where Karbi Anno?
Kamrup.
Nearby. Then also
Yes,
they
that
don't know.
near bridge, Lordship. I mean,
Nearby also they don't know the law. See,
yes.
this is done under the Assam Land
Assam
Requisition and
Land
Acquisition Act.
Requisition
How is it
Act.
possible of de-requisition? You cannot do that. Goodness. Ahok, list this matter again on 14th of September. The district commissioner, Kamrup, rural, shall apprise the score on what basis the order dated 25/1/2000 on what under what law the order dated 25/1/2025 was passed de-acquisitioning a plot of land. In the opinion of this court, the said order appears to be non-est inasmuch as there is no such power under the Assam Land Requisition and Acquisition Act 1964. Once the land vests upon the state by virtue of a notification in the official gazette made under Section 6 of the Act of 1964. Let him make
Lordship has fixed it on
14th.
Deep request.
Yeah, my love, I pray for 1 week time, my love.
What is that?
Payment of
Social justice.
Lordship, I have received mail from the department which said that the Sokhi.
You are also like Mr. K. Gogoi. You keep on appearing for central government also.
No, your Lordship.
Which
In
department?
fact, social justice and empowerment.
Social justice, water resource, and which one? Let us also know where Miss Ardeka is.
Social justice, water resource and Dima Hasao, your Lordship. Lordship, in fact, it is wrongly stated before your Lordship that the Social Justice and Empowerment Department is the main authority. In fact, it is under the response number 1 and 2, your Lordship, Women and Child Development. So we are not the competent authority, your Lordship. Social Justice.
Who is the woman there?
It's Women and Child, your Lordship. My learned friend will advise you.
Huh?
We are also not party here, your Lordship, but Lordship has requested, directed us to take instructions on the basis of some submission that the nomenclature of the writ petition has been changed.
Has been changed.
No, your Lordship, it is under the Women and Child Development.
The department still has.
Yes, your Lordship.
Who is paying for one? Okay, verify and pay that amount. 6 months. Payment, na?
Payment.
On payment.
Yes.
Okay, verify and pay within 6 months. Certified copy, the direction is to the response number 1 and 2.
Yes,
1, 2, and we only require 1, 2, and 3.
Lordship.
And the payment, the certified copy will be given to number 2.
My
Director.
Director.
From whom are you to get the money?
Lordship, it is from the Deputy Commissioner,
Huh?
a joint account of the District Social Welfare Officer and Deputy Commissioner, my lord.
Okay.
Lordship,
So we directed the year to be given to the district commissioner, but the direction will be for response numbers 1 to 4.
Lordship.
1 to 4 shall make the year jointly and severely,
My lord.
and the certified copy would be given to number 4.
Lordship.
Verify and pay.
Lordship.
6 months. What is it?
Lordship, my lord. My lordship, may be pleased to.
In terms of the order passed earlier, my lord, they have failed to extend the bank guarantee.
No, your lord.
And now, my lord, we have already approached the bank, my lord, for my lord, within 10 days, we are supposed to extend the duty.
If I may-
But, my lord,
Okay, now what happened?
no, my lord, an IA has been filed by the bank, my lord.
Your Lordship, we approached the bank for extending the bank guarantee. Then the bank told us that since the bank guarantee has already been revoked and cancelled, they cannot extend the bank guarantee. And
Invoked.
it has been invoked in the first instance, so they cannot extend the bank guarantee. It has to be renewed. We said the court has directed us to approach you, do what needs to be done. But since the order was for extension, they have come up with an application for modification, seeking your lordship permission to renew the bank guarantee. Money is already lying with the bank,
A fresh
4 crores
guarantee.
and all.
A fresh guarantee may be issued, my lord, with the same account.
Huh?
The cause of action will change. The bank guarantee, which is the.
Mr. Counsel, I am doing it for your protection because the orders which have been passed by our coordinate benches totally nullify your case. You would not get a single penny. When we are trying to do it in your favor to kindly help him out and get a renewal so that
My lord.
your interest is protected.
Yes, ma'am.
You should not object and come up with all this infructuous business.
My lord.
Yes, he is coming out here for an IA for the purpose of modification to the effect that they will renew the bank guarantee.
My lord, issue a fresh bank guarantee.
Will issue a fresh
That-
bank
that,
guarantee which will be valid till the pendency of WPC number 489.
My lord, my lord, for 3 months because
No.
technical. My lord,
Your lordship, 3
Pendency
months.
of WPC number 489.
My lord.
Otherwise, it cannot be.
Yes, my lord, that can be done.
What do you say? Because when there is a stay order operating, this court has passed the stay, some stay order. So this, your protection has to be there. There has to be the renewal during the pendency for 30 days. During the pendency and 30 days thereafter.
Same
1 year.
bank guarantee could have been renewed. my lord.
Right? No, my
The
lord.
same bank guarantee.
Let it be a fresh bank guarantee on the basis of the orders passed by this court. This will be taken as a continuation of the earlier bank guarantee.
The only problem is that the BG number which was issued earlier, that has been cancelled. A new BG number has to be issued.
So therefore, we direct that you issue a fresh
My
bank
lord.
guarantee in continuation.
My lord.
And this will be treated as a continuation of the bank guarantee.
Well, that can be, your lordship may pass the
And a
direction. that-
copy of the same we provided to them. You will have it, which will be pending till the disposal of this and 30 days thereafter.
The amount followed will be given by, it's already lying with the bank.
Yes, my lord.
Understood, the
That's why
bank
we'll-
is there, but one needs to, you say, Mr. I think what will do, we do one thing, the earlier modification which was there, we recall that. You will recall it? You'll be happy? When we try to help you out, you are causing problems. No. Heard Mr. M. Smith, the learned counsel appearing on behalf of the petitioner,
For the applicant, my lord.
the applicant.
In
That
the
is the applicant, that is the respondent number 7 in the accompanying writ petition. Mr. H. Gupta appears on behalf of the opposite party numbers. 227. And Mr. D. Senapati appears for the respondent number 1, opposite party number 1. This is an application filed by the applicant oblique the respondent number 7, seeking modification of the order passed by this court dated 10/8/2026 on the ground that the bank guarantee bearing BG bond number, a number to us, page 30 number, dated 22/10/2018, having already been invoked on an earlier occasion.
Invoke and cancel, my lord. And cancel, my lord, the bank guarantee.
Invoke and
Slash, but cancel. Invoke, my lord, actually, yes, my lord. Invoke.
having
Invoke.
already been invoked, the said bank guarantee bearing BG bond number so and so cannot be, remains non-negotiable. Non-negotiable. And accordingly, for the purpose of effective compliance to the order dated 10/8/2026, this court may modify the said order, thereby permit the respondent number 7 to issue a fresh bank guarantee in continuation of the bank guarantee bearing number so and so, thereby in favor of
Opposite party number 6. Opposite party number 6.
of the respondent number 6 till the pendency of the writ petition. Mr. D. Senapati, the learned counsel appearing on behalf of the writ petitioner, submits that the writ petitioner have duly approached the respondent number 7 for the purpose of extending the bank guarantee bearing number so and so, dated so and so. However, in view of the said bank guarantee having already been invoked, it was informed that the said bank guarantee cannot be further extended. The learned counsel appearing on behalf of the petitioner submits that the petitioner would make the necessary, would carry out the necessary formalities before the respondent bank within 10 days from today. 10 days?
It's already done. No. After your lordship direction, then only we can pass.
Okay,
the-
we'll again
But
approach.
at least 15 days.
Submits that the necessary formalities have already been carried out.
It is not carried. We are waiting for your direction. my lord.
By them.
By them, yes, they have carried
Have
out.
been carried out at the end of the writ petitioner. in that regard. So accordingly, this court therefore modifies the order dated 10/8/2026 with a direction upon the respondent number 7 to issue a fresh bank guarantee wherein it shall be duly mentioned that the said bank guarantee is in continuation of the bank guarantee bearing bank guarantee bond number so and so of the amount which was guaranteed by the bank guarantee bearing number so and shall be valid and favoring the respondent number 6 na?
Opposite party number 6.
And shall be varied for a period of during the pendency of the writ petition 30 days thereafter. This court further observes that upon issuance of the said bank guarantee in favor of the respondent number 6, the respondent number 6 shall not revoke the bank guarantee till the disposal of the writ petition. I stand.
Your Lordship, will your Lordship fix a date for the hearing the writ petition?
Okay. Writ petition, when do you want?
September.
First you do that.
Okay, much
No,
time
do
period.
that. Full stop.
My Lord, 10 days.
Liberty given, liberty given to the parties to mention the matter upon the submission of the bank guarantee by the petitioner.
An applicant, my Lord. By the applicant, my Lord.
Huh?
No. I'm meeting.
He has to give,
I have to give the.
will be issued by him. Why will he go?
We can also, but since he's already approached the bank, my Lord, we can.
Can you give it to him? You
No,
don't give
we
it to
can
him.
give it to him, my Lord. If a Lordship gives a direction, we can give it to the petitioner as well as the rest.
No, whoever, normally what is the,
original has to go to the railways.
how, who is going to give?
Bank usually give or they give it to us and
Normally
we can.
they give, na? You give it.
Much of.
Upon the writ petitioner providing the bank guarantee to the petitioner. Upon the respondent number 7 providing the bank guarantee to the petitioner. Respondent number 6.
The time period, 10 days time was given by your Lordship.
No, I've given 10 days. No, I've given the formalities. He has commented, so you do it within 10 days and give it to him. I disposed. Yes, Mr.
I have received my instruction, my Lord.
Huh?
File my affidavit to allow me to. He is challenging an order, my Lord. Temporary arrangement order, my Lord.
My Lord. Anyway, don't fight at 5 o'clock with Mr. Okay, the respondents have not filed the affidavit in spite of notices have been issued as far back as on 17/2/2025. The respondents in the GMC as well as the private respondent are given the final opportunity to bring on record the affidavits on or before 5th of October 2026. Liberty given to the petitioner to file reply there against. This is the matter on 14th of October 2026.
May I pay for tagging this order with WBC 7200/2025?
Why?
This will have a relevance because the respond number 4 in pursuance of the direction of this honorable court was supposed to given the allotted land.
Now, on the allotted land not been given, we institute a writ petition wherein your lordship has directed the authorities to take a decision. Now that writ petition is pending. Since the authorities could not give us
Okay.
the land, they
Is
have
it
given us
connected?
connected.
Connected?
No, my lord. Actually, my lord, they are the street vendors. They have given Pamohi, my lord. Your lordship, there, but in
My lord,
Fancy
the
Bazaar there is no mention.
Last,
They are in
no,
inside the
last-
Fancy Bazaar.
Last annexer of the writ petition is the lordship's order in my writ petition.
So only Pamohi.
You file your affidavit, we'll look into it. Yes, but
In this case, Lordship, 2 weeks time may be given, Lordship. Respondent filed their affidavit in opposition that I have to respond, Lordship.
In
2 weeks time.
In this case, your lordship has directed us to bring on record the letter which was issued to the NHI DCL by Kala.
For what?
That's because lordship, beyond the 3D notification, no land has been acquired. That was the case, lordship. I have annexed that document as Annexure A, page 62. As because this letter was placed by the my learned friend on behalf of NHI DCL, so your lordship has directed me to bring this.
From after site measurement, it has been found that the ROW pillar marking a dark number in month part 2 is as per the acquired land under 3D.
Accordingly, lordship, in paragraph 3, lordship, I have mentioned at page 60.
So therefore, there is no other land acquired.
No.
Here the case of the petitioner is that
Lordship, boundary set out beyond the acquired land. This is my case, Lordship. So, Lordship,
but there will be a requirement of a verification. That's all.
Lordship, I'll
You want to do what?
2 weeks time to respond to the affidavit in opposition, Lordship.
Small affidavit.
Lordship.
And why the other matter?
Lordship, it is other which are already infractious, Lordship.
1671.
Lordship. Other matter infractious.
Mr. Ella Mojumdar, the learned counsel appearing on behalf of the petitioner, submits that the instant petition has become infructuous and as such petitioner would not like to further pursue. Taking into account the above, the petition stands closed as it has become infructuous. Ms. So-and-so appears on behalf of the NHIDCL and Mr. So-and-so appears on behalf of the Kala. And in this case, 2 weeks' time is granted to the petitioner to file reply to the affidavit in opposition. So list this matter again on 9th of October 2026.
Single people.
May I please your lordship, kindly pass over this matter for a short time being, as my senior is on our way to court.
My lord, the respondent one has not filed their affidavit, my lord.
You are getting an interim order, you are enjoying an interim order.
I have a periodic patta, my lord. Now
What is the interim there here? Shall bring the stay and issue the year. What is the interim order?
interim order, lordship will find 16/7/25.
16?
16/7, my lord.
The litigation
Not to
in
disturb.
possession, it is provided the possession of it shall not be disturbed till the next.
I have a
It
periodic
is seen that the respondent, who has filed the affidavit?
respondent 2, my lord.
15/7, respondent number 2. Who wants the time?
Me, my lord.
Affidavit filed.
Affidavit filed, my lord, but respondent 1 has not filed, my lord.
Is it required?
Maybe, my lord, because they are now trying to oust from my patta land without cancelling my patta, and they want.
No, number 2 is filed. Number 2
number
is the number 1. Not required.
My lord.
Not required. It is there. We have filed your reply. So we can dispose it up on any date.
Yes, lord.
Urgency, no urgency.
No urgency.
Okay. Pleadings are complete. However, there is no urgency in the matter for which the matter will be listed again on 13th of November 2026.
Interim order, my lord.
Interim order passed earlier shall continue till the disposal of the writ petition.
Obliged.
Non-payment?
Yes, ma'am.
Which department?
But a cooperative society, my lord. They
Operation department,
have already
pay
filed-
that. Verify and pay within 6 months.
already verified, my.
Huh?
Filed the affidavit, my lord, admitting the claim of the petition.
Admitting?
Yes, my. Supporting what due to
Where?
non-sanctioning, my lord, they could not file.
Affidavit file, admitting 14 lakhs.
My lord, 16,78,000, my.
Huh?
16,78,000,
But they are admitting how much?
my lord, entire, my lord. As paragraph 8 and 9, my lord, they are affidavit.
Receive from the hospital is so and so. What is the amount admitted? Where is the paragraph?
My lord, in our writ petition, we have annexed, my lord, page number.
Where they have admitted in
My
their
lord,
affidavit?
8 and 9, my lord. Page 25.
Stated is a matter of fact that a record that there is a budget provision of SS which is amounts to remand and LS which amounts to remand, which are allocated by the finance department doing so and so, so and so, so and so. Okay. There's no specific admission. You verify. You verify and pay within 6 months. This part.
So my name wrongly reflected in this matter, Lordship. Actually, I am not standing counsel of hospital, Lordship. I am the standing counsel Assam State Housing Board.
Your name to Nidibo.
Hi, Lord.
Lordship has disposed of, my lord. Dispose of.
Dispose.
My lord. Always, my lord.
Lordship, non-payment of bill, Lordship.
Which department?
Lordship,
The GMC,
Yes, GMC is a different ball game. So why it has not been paid?
my lord, first of all, my lord, a part of
Whether
the,
he is entitled to the amount.
they have done it, my lord, but they have a portion from 2 to 22 to 8 to 22 without any order that they have said that they have worked it, but there is no formal order.
How much is the amount of claim?
Lordship, it's 63 lakhs, Lordship, 12,355.
And that part is amount of 5 lakh something has already been paragraph number 7 of my affidavit. That part is amount 5,37,880 rupees. That has already been rejected, man.
And the remaining amount of 57 lakhs have been not certified by the executive engineer.
Lordship, not Lordship, already signed Lordship, certified Lordship.
And
In
the thing is
other
that-
cases, Lordship, in mine, not, in my case, Lordship, all had been signed by the executive engineer, Lordship.
And also, my lord, thereafter that Chief Minister Vigilance Cell has seized this record. And now the entire record is placed before the Chief Special Court, my lord, Assam.
Huh?
Special Court, Assam. That's the difficulty, my lord. The entire record was seized by the Chief Minister Vigilance Cell. And now cases are going against the engineer. So this record is placed before the Special Judge, Assam.
Okay, take the certified copy of the records inquire the petitioner. You cannot take that. There can be very well an application filed that to provide you certified copies. Because of that, the other people should not suffer. And is the petitioner an accused?
The petition, no, the entire record, the petitioner now that
Is the petitioner an accused? No,
Petitioner-
then can the petitioner be put into harm's way because of the fact that somebody's
is a 5%.
investigation, somebody has committed something? So therefore, you do one thing in the meantime. You are not in a position to verify.
That's the difficulty on the part of the
Okay,
verifying.
we pass. Mr. Espora, appearing on behalf of the GMC, submits that though the claim of the petitioner is of the amount of rupees 63 lakhs 12,355. However, in respect to an amount of rupees 5,37,880, there has been no work order issued or any justification was submitted by the then executive engineer GMC. It is also mentioned that as regards the remaining amount of 57,74,475, further verification is required, but on account of the files in connection with similar tenders having been submitted before the
It's a
Special Judge Assam, the necessary verifications have not been able to be carried out. It is the opinion of this court that either the Chief Minister's vigilance cell vigilance inquiry, na?
The Pista Witness Cell, my lord.
Vigilance cell, or even the petitioners can file a due application before the special judge. Seeking certified copies of the documents or certified copies of the documents. Inasmuch as on account of the entire file being handed over, being submitted before the special judge, the petitioner who have no dispute, they have no relation in respect to such offense, cannot be put in difficulties and thereby deprive him of his necessary dues.
Lordship, may I draw Lordship attention, Lordship, in page number 42, Lordship. Files are, Lordship, already in Chief Engineer's Lordship hand, Lordship. Kindly 42, Lordship, page number, my read petition, Lordship. Page number 42. Lordship. With reference to the subject cited, 16 files that were returned by CM Vigilance and subsequently forwarded to the undersigned by the CE branch are now being returned to Chief Engineer branch for safekeeping until further instruction by higher authority in regard to possessing. Lordship,
Mr. Bora.
No, my lord, my affidavit, my lord. Lordship will kindly see my affidavit. Page number 50, running page, paragraph number 5. That is the file number, my lord. GGR/C 226 of 2021.
Which one? Page number?
Page number, see, running page number 50, paragraph number 5. That file, because the entire thing, these are different file, work order file. There
these
is a
are the
different one.
file, Lordship, 43 and 44, Lordship. These are the files, Lordship.
Okay, let this order remain. This court also have taken note of. Accordingly, list this matter. On 9th of October 2026 for an update. Otherwise, let them take certified copy. Yes.
Land acquisition corporation as well as the Jirat. Well, response number 2, the DC has filed an affidavit at paragraph page 52, Roman 4. Well, they admitted the amount, the compensation amount determined as 28,23,840. Well, so they may be directed to the.
What is the amount? For what amount? Jirat is for what?
Jirat of the National Highway Authority actually for construction of that toll tax collection gate at NH 37. They acquired my.
How much amount you are entitled to?
Well, this is determined by the DC, and it is mentioned in their affidavit at page 52, para Roman 4. 28,000 lakh, 23,840.
You got 10 lakhs, 6 lakhs. What is the sale deed required?
Actually,
Yaqub Ali has
made a
raised-
indication. There is a what happened? The land acquired process is initiated in 2009, as stated by their affidavit. One person, Yaqub Ali, one part of the land was there is that agreement was took place. Subsequently, it come to an amicable settlement. I paid him 12 lakh instead of remaining 6 lakhs. That dispute has already been settled.
There is a requirement of execution of a sale deed. By whom?
In fact, my affidavit supports him, my lord.
Not sell
In
it.
fact, my affidavit supports him only. my
Now
lord.
kindly look into this, Roman 4, page 52, last time. He himself entered into an agreement for sale in respect to the
It is
land
regarding that
whereby the
dispute.
petitioner already agreed to sell
That
the
dispute.
land to Yaqub Ali at a total consideration of 10 lakhs, out of which 4 lakhs have been, 6 lakhs have been paid and agreed to pay.
Yes, ma'am.
Hence, it is required to discuss the legality and of the enforceability of the agreement. First, after the publication of the central government as so and so, so and so. Title deed. In absence of title deed, since so and so is not tenable. Then so no, due to non-registration of the agreement or the agreement was so and so, and thirdly so and so, so and so. Now, who is the petitioner?
Now petitioner is
Are you the owner of the land?
I am the owner. Mistakenly, we have come to entered into agreement with a particular plot of land with
Yaqub
one
Ali.
one Yaqub Ali. There is a settlement that has been described in my writ petition. It is supported by the government in their affidavit as well. Due to some allegation made by that person, the compensation amount was not released to me. Now it is from the affidavit submitted by the DC. It
Where
is
is it?
clear that I am entitled to 28 lakhs, 23,000.
Where is that statement?
That is page 52,
Roman 4.
Roman 4, my lord.
Where is that? That is not there.
My lord, it says, my lord. May I read it, my lord?
No, no. Earlier, as per the procedure, the assessment of the AI in respect of the AI is done and the value of assessed so and so.
Yes, my lord.
At the time, the record reveals that one Yaqub Ali and so and so, this case has been going on. Now, therefore, all these things, hence it is required to discuss the legality and enforceability of the agreement for sale. All these things are done. Then what happened? That of
Titles-
so and so, title suit number so and so and so and so, agreement for sale between the petitioner and so, in respect that has no legal right and it has no legal to enter into an agreement for sale in respect of land which is surveyed by AI for acquisition. The agreement has no legal. Secondly, so and so. But where have you said that he is entitled to that? You say that you have said. You have not stated that you are ready to pay.
Yeah, that pleading is missing, my lord.
That is the main paragraph. That is why while reading this affidavit, I couldn't find all these things.
My lord, in the
You
last
are
part,
saying you are saying all things.
I also understand, my
The
lord.
thing which is required has not been said.
Otherwise,
You see,
my
you
lord,
can very well decide all these things under 3H2.
Yes, yes.
This is to be done by a competent authority of land acquisition.
my lord,
The way the competent authority of land acquisition is not doing it. There is no dispute as regards this, and he has already looked into it.
But moreover, my lord, agreement for sale after notification.
Chalo, list this matter on Friday at 2 p.m. for final disposal.
hello.
We finish it off. This is a small order is required.
This is
Yes,
with regard
Mr.
to
Dutta.
widening of a road, my lord, without paying compensation, my lord.
Huh?
Widening of a road, my lord, over Patta land. My lord, Lordship had, on last order, Lordship had directed my lord, the circle officer, the PW, my lord, placed their stand. The circle officer has filed an affidavit, my lord, saying that it is the executing department, there's a PWD, who has to, my lord, say whether what is the additional land required. PWD, of course, has not filed an
They
affidavit.
filed the affidavit.
PW has not filed, my lord.
We
Only
have
the
not.
circle officer has filed.
The circle officer affidavit is
It was filed on 24th, my lord.
directed. PWD has not filed.
Lordship.
Where you are not filing?
Lordship, because we have just received the instructions, but those instructions are also not really clear.
Mr. M. Bhuya appearing on behalf of the PWD seeks for some time to file the affidavit.
Lordship.
In as much as the instructions which have been provided to him is not adequate and more not specific and further not specific to the order passed by this court on 7/8/2026. Taking into account the above, list this matter on 9th of October 2026. In the meantime, the affidavit on behalf of the PWD be filed. Petitioner is also filed. So the interim order is extended till the next date.
May please, your lordship, that cattle market, petition lordship, that cattle market matter, lordship.
What?
50
Get and
58
make there is no urgency.
Lordship, and there is already a stay order in this, by this court, status quo is already.
No urgency.
No, lordship. No
Why
urgency and
we have it
lordship
in the
in
month of January.
59.
Unnecessary pending, my lordship may fix a date for final.
No,
disposal.
this matter how much you dispose. It
Again
is
and
again going to come up.
For that, my lord.
It is
Lordship-
better to
lordship-
keep it pending, lordship, and to.
Once
Pending also,
you
it will
see,
not help, my lord.
normally the people dispose of a writ petition so that it is an end to a litigation. In this case, once we dispose of a writ petition, another writ petition springs up.
My lord, all the cases are admittedly private markets, my lord. And now, as per 107, government has the power to grant permission, my lord. So lordship can dispose it of, my lord, sending all the repetitions to the government to decide, my lord.
Didn't they pass the direction earlier?
One direction was there, my lord. I have
No,
second
no, I
instruction.
made it clear that you need the directions of two persons. One is the Gaon Panchayat and the other is the government.
My lord.
These two directions I made it very clear.
My lord.
But why should I again keep
But
on asking?
now, my lord, 3 repetitions are before your lordship, my lord.
Two.
No, one
Two are
is not-
claiming the same market
Huh?
and one another, my lord.
872 and 1200. Only these two.
And madam is there.
My lord, the already approval has been granted.
Who?
Now against the approval has already been granted by the panchayat, Gaon Panchayat. And against that approval, they have come here and they are seeking that approval. You go to the government and take the approval.
Now instruction from
We
government
don't
is,
have
my
the
lord.
government approval.
No, my lord.
Oh, we close it.
That
We
is what,
close
my
them. You cannot allow without a year.
No, lordship,
Yes.
panchayat has.
No.
given the
This type of
approval.
petition immediately. I passed the judgment, made it very clear that there is a
Yes, yes.
requirement of the Gaon Panchayat.
My
in
lord.
here. On account of that status quo order, he's doing it. Where is
Yes,
that
yes.
writ petition? We immediately take that. Yes, this is the matter. 872.
872, there is a status
Yes,
quo order.
interim order. This order is creating the problem. 16/3/2026.
Now
There cannot
government
be a
instruction
status
is
quo
that,
to
my
that
lord.
effect.
Now my
It will
instruction,
be in violation.
my
But
lord,
lordship,
yes, yes.
no one filed any vacating.
Not
petition.
necessarily I vacate, I'm not extending it.
Lordship, for that,
Interim
your
order till
lordship,
the next date.
then lordship may fix it at any date at 2
I'm
p.m.
not
lordship.
extending it, no.
This matter is
They
supposed to be argued by. Mr.
Nowadays I
Ken Chaudhary,
look
sir,
into
lordship.
it, which lawyer is there? How many lawyers? In 1 month, one lawyer for 2 p.m. Not for all matters.
We will take care of this.
No, you have already lost your chance for that. Today
Lordship.
your one matter is done.
Actually, government,
Lordship.
No, you cannot. This type of, anyways, list these matters
We
again
have already applied, lordship.
on
Friday.
29th of September 2026, on which date an attempt shall be made to dispose of the.
Lordship, in item 59, we have filed an application for implement, lordship. In that case, they are claiming that the same market they are claiming on the basis of NOC which was given to the petitioners. of
Okay,
item
list the matter for final disposal on 30th.
Obliged.
30th.
30.
Interim to be.
308
Not here.
or 9?
September.
309.
Lordship. Interim to be continued.
No, this type of interim order I don't pass.
Interim lordship only till today, lordship.
Oh, first of all, okay, let me make it clear. Learned Senior, Ms. R. Chaudhary, the Learned Senior Counsel have asked for an extension of the interim order. Full stop. This court is of the opinion that this court extends the interim order with a further observation that the interim order that the petitioner herein no, full stop. This court has sought for an extension of the interim order, wherein there is a direction that the status quo be maintained. Full stop. It is the opinion of this court that section 107 of the of the Panchayat Act, Assam Panchayat Act 1994 makes it clear that there is a requirement of the approval of the Gaon Panchayat as well as of the government. In the garb of the interim order, the petitioner admittedly does not have any approval of the state government. And under such circumstances, on the garb of the interim order, the petitioner cannot continue to run.
But Lordship, we have prayed for approval before the government.
So
and
what?
They are,
Can there be a deemed permission?
they have not allowing.
So
any
therefore, there
approval.
whatever may be,
For
but
that, I
they-
have
for
instruction.
that appropriate direction can be cast. But this court, don't ask me. Don't ask for that interim order extension. You know what to do.
And Lordship, in the meantime, one of the petitioner died. We have filed one IA for Lordship substitution.
So therefore, I have fixed it on. Okay. Now I think best of list the matter on 17th of September, 16th of September.
Okay.
Interim order extend.
18th of September.
Take adjournment. I am not sitting.
Obliged.
So let it before the.
Then it will be much easier for that. No. Let us take, it's already 5:30.
Obliged.
18th of September.
18th, you see, madam, 18th, why I'm not fixing it? If you see 18th of September, I have already fixed 44 matters. 17th, I've thought 26. We can have it on 16th,
Any date after 18th.
23. Okay, on 23rd of September.
I'm good.
Obliged.
We extend the interim order then.
Then
You
Lordship.
have asked the changer. Interim order passed earlier shall continue till the next.
Highly obliged, Lordship.
With that interim order, because of that interim order, the state government is unable to proceed and they are coming and saying here that approval is not granted. We have already granted approval pursuant to that directions. So they are asking an order against them and they are complaining that I'm not getting approval.
My instruction is that they are asking for specific day, my lord, Friday, but district commissioner has given Tuesday. That is why
Who has given?
district commissioners, my lord,
How
and
can the district
the
commissioner?
Gaon Panchayat, my lord.
Now forget about Gaon Panchayat.
My lord.
I'm asking you as regards the government.
107. The government, my lord, they have specifically praying for only Friday.
Now, has the government given?
Not
the-
yet.
No, Lordship.
Not yet.
Panchayat has given
Not yet.
Lordship 7 markets, 7 days, Lordship. And 7 markets were granted permission on 7 days, Monday, Tuesday, Wednesday, Thursday.
No, it's okay.
And
Let it be.
status
on-
quo is also there, my lord.
And for status quo, Lordship, government was not debarred from granting any approval, Lordship. Government can grant.
Order, my lord, without approval, no market can be run actually. The court also will not grant any order that without approval you run the market. That also perhaps the court did not mean.
The Gaon Panchayat's approval is where?
My lord, for their Tuesday, my lord.
This is the
Then-
impugn order, Lordship.
Only for Tuesday. They are
This is
asking
impugn
for
order
praying
in
for
our
Friday.
Oh,
Petitions.
this type of case.
If there is a stay, then no one can run actually. Because there is a stay. That approval which is granted, that is stay. So there is no approval, so no one can run.
Who has got the state? Which
Well-
approval?
Let us go.
Status quo is
Not a
stay.
No, Lordship.
Saying on the basis of that status quo order, without approval, someone is running the market. So without an approval, whether on the basis of an interim order, any market can be run. For us, I have got nothing to say. We are the authority, we have given the approval. For us, I have nothing to say because we have given the approval. They don't want to.
You are for whom?
I have.
Panchayat.
Panchayat.
How did you enter into Gaon Panchayat? You were running some market earlier.
Yes, Lordship, that is exactly the same.
Gaon Panchayat.
No, you were running on behalf of the Anchalik Panchayat. Yes.
Actually, that is
Yes.
my lord. That is
You were running on behalf of the Anchalik Panchayat. Mr. Pran Bora was appearing on behalf of the Anchalik Panchayat.
for the order.
Whatever may be, now you have now become the Gaon Panchayat.
Also, I was representing on behalf of the Anchalik Panchayat.
It's okay. Okay.
That is why I prayed, my lord, to the government have to be interfered for all the markets, man.
So you have the power. So, yeah. interim order stands extended till it's extended. It is made clear that the extension of the interim order shall not bar the Panchayat and Rural PNRD department, PNRD to take due action if there is non-compliance to section 107 of the Assam Panchayat Act 1994.
Highly obliged, highly obliged.
The date remains the same. The date remains the same.
23rd. Yes, any urgency? Hey, I rise out here now. What is this matter about? Mr. Goswami?
Lordship,
Relating to lordship, non-issue of fitness certificate or health.
Huh?
Lordship, what happened, Lordship? The petitioner is the authorized at.
Not authorized.
Uh-huh.
Authorized, no certificate.
Oh, that certificate.
The certificate, Lordship, that certificate, as and when they want to transport the cattle, Lordship, they have to apply it for the authority, Lordship, district authority. And district authority, after verification, Lordship, issued the certificates, Lordship. Here, in my affidavit, I categorically stated that the grievances of the petitioner is that the district Dhemaji and Lakhimpur, they stated that they applied for cattle certificate, transportation certificate, but we refused, Lordship. But in my affidavit, I categorically stated that the district Dhemaji, they has not applied till now. No application submitted by the petitioner. In Lakhimpur, Lordship, there are 2 applications they submitted.
This matter on 9th of September 2026 for final disposal.
Lordship.
Any urgency of the interim orders, any matters, quick, get your matters.